Commissioner Greg, good to see you. I'm fine. Oh, I did, yes. Right, and they did mention Delaware.
It's horrifying. Yeah, I know. I just, that's kind of, and I'm not trying
Yeah, but I mean, can you get your emails off something other than your phone? I mean, off something other than your watch.
We're getting there.
Yeah. Like people who were born today. Still in 8th grade.
Good afternoon, everyone, and welcome to the February 19th, 2020 Public Service Commission meeting. Just for purposes of administration, number 6 on the calendar. I believe will probably take a little bit longer than the rest of the people on the calendar want to wait for, so to speak. So we're going to move number 6 and accommodate some other people and move that to basically just before public comment. So that we'll have, we won't inconvenience anybody else, and everyone can get their 2 cents in about what the commission should do.
Mr. Chairman. Thank you.
Thank you very much. We have the reading of the meeting minutes of January 29th, 2020. Any changes, corrections to the minutes?
Move we adopt the minutes as presented.
I second.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
I abstain. Motion carries. The consent agenda, is everybody okay with the consent agenda? Hearing nothing, we will proceed with the consent agenda. May we have a motion?
I move that we adopt the consent agenda.
Second.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
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 Any opposed? Any abstentions? The motion carries. On the regular agenda, number 1 is in the matter of the provision of standard offers supply to retail consumers in the service territory of Delmarva Power and Light. And Ms. Knotts, you want to proceed, please?
Thank you, Chairman Winslow and Commissioners. As you know, each year, the Commission's technical monitoring consultant prepares a final report that summarizes the results from Tranche 1 and Tranche 2. In order number 7053 dated October 17, 2006, the Commission stated that certain information from the tranches can't be released until 21 days after the approval of the last tranche. And prior to that, winning bids and winning bidders are still confidential. Well, today happens to be the 21st day, so Dr. Ledzeller from Liberty Consulting Group is here to present a summary of the final report for your acceptance. And the public report will be posted on the Commission website after today's meeting.
Good afternoon, Mr. Chairman and Commissioners.
Doctor, by the way, you look very good on TV. I watched your last presentation.
I play one on TV, I guess. Thank you. Well, the highlights of the 2020 RFP, if you would please move to the first slide, thanks. are that the RFP covered about 540 megawatts of load. The results were very good, including strong participation from key regional energy providers. The process was run very well, and it was successful from start to finish, and the bids were consistent with the expectations we had given the market conditions. And most importantly, the auction prices reached all-time lows, and this is largely due to low wholesale energy prices. Next slide. As an overview of the 2020 RFP, there were 13 blocks totaling 540 megawatts. As usual, Tranche 1 had blocks for risky MGS, LGS, and GSP customer types, and Tranche 2 had only risky and MGS. Broke it down as follows in the table. Next slide, please. Now for the results of the winning prices on the year for 2020 compared to 2019. For risky, where we compared only the 2019 24-month blocks to what are now all 24-month blocks, the prices that we achieved were 8.6% lower than last year, MGS 3.8% lower, LGS 3.1% lower, and GSP 6.8% lower, which will then translate into ultimately customer bills being lower as well. Next slide. And to display an estimate of those customer bill impacts, I'm showing here a table that was filled with data provided by PHI's analysts. And as you can see, that residential class average customer of about 840 kilowatt hours a month will see a 1.1% reduction in their bills. Small general service, non-demand customers, between 1.5% and 1.8% reductions. MGS between 1.9 and 2.6% reductions. LGS between 1.9 and 1.7% reductions. And GSP between 0.6 and 4.3% reductions. Very good results overall. Next slide, please. As I mentioned earlier, there was strong participation and competition, and we saw the highest number of bidders participating since 6 years. And this was because we had 12 12 expressions of interest, which led to 9 eligible bidders, and all 9 bidders ultimately did bid on blocks. Next slide. In Tranche 1, the risky and MGS blocks each had 7 bidders for each block. LGS had 3 and GSP had 4, all completely acceptable levels of participation. In Tranche 2, all of the risky and MGS blocks had 8 participants. Very strong. Next slide. The winning bidders are listed here: Axpo, DTE, Exelon, Hartree, Nextera, and TransAlta, with Axpo being a new entrant and winner this year. Next slide. These same 6 winners comprise the suppliers for 2020 delivery, which also includes that some of these were winners in 2019's 24-month blocks for risky, which the second year of those contracts is being served in 2020. And what's interesting here is that 5 of the 6 represent winners and suppliers in 2020 for the risky class. MGS, where there are fewer blocks, there are only 2, Nextera and TransAlta, with 1/3 and 2/3 respectively. Then, of course, LGS and GSP are single blocks, so they are served by a single customer. But overall, we see a very high level of diversity in the suppliers, which is always a good sign. So in conclusion, all the processes, including the auctions themselves, were run well, and they resulted in bids that were consistent with market conditions. Participation was strong, and the auctions were indeed competitive, which of course led to prices for all customer classes reaching record lows. Finally, there was one issue we wanted to discuss, and that's that we recommend that Delmarva and the commission addressed the issue that there has not been a PJM capacity auction to cover the 2022 and 23 delivery period, which would be the second year of the 2021 upcoming risky contracts. And I do know that the commission staff has already looked into this, and I've spoken with them, and as I've spoken with PHI, and they're on it, but there are no solutions confirmed yet. At this point, they're going over their options, and will analyze what the best course is to continue on.
So what camp are you in? What's your answer to the question?
Well, at
Now, have it soon, and accommodate the people who want to make the bids, or accommodate the other group that wants to delay and give states more time and give other people more time?
Well, there are a number of options considered, and the first thing to know is that other states are dealing with the same issue. It's going on in New Jersey and DC and
Pennsylvania, Maryland.
for example. And, fortunately for PHI, they have, their parent company has operating companies or PHI operates in all of those states, so they're seeing what's going on. So there are some things on the table already, including putting in a proxy price for capacity and proceeding through the auction as regularly scheduled, and then updating that price with the actual price, which would then flow through to a change in the bid price. That seems to be a popular approach right now, and no one has, I think, confirmed exactly what they're going to do, but those are the schools of thought. Another possibility, and this is just my own thought on this, is that in the case of Delaware, where it is a 24-month period, it would be possible to just do a one-year auction and then follow up with the second-year auction at a later date. These are just possibilities at this point. For no reason do I think the auction should be delayed, the SOS auctions, just because the capacity market is delayed. It's just how you will play into that with either delaying the second-year auction or using a proxy price that would be updated later. But like I said, PHI and commission staff have already begun discussions on that, and I'm sure they will come up with something that works for everyone.
Okay, thank you.
You're welcome. That concludes my presentation. If there are any other questions, I'm glad to answer.
I don't have a question, but I just want, it's very encouraging to hear you today, because the last time, I guess a year ago, we started to have a little bit of concerns about the number of people in the auction. Not a lot, but just some thought came to us about who was playing in the marketplace. So this year is very encouraging, and so we're happy to see that. And the prices, obviously, we're happy with. Do you have a graph that shows over the course of time, you all have been involved in this, where the prices have gone ups and downs?
Not with me at the moment, but we have all of the data, and the prices, as I mentioned, are at record lows. They were substantially higher, I recall, 8 years ago when I personally became the commission's monitor on this. The prices were, I think, in the 80s, so don't quote me on that, but and now they're in the high 40s and low 50s. So it is quite substantial. I would be happy to follow up with a chart that shows how it has changed over time.
I would appreciate that. And just another observation, of course, Sam will already thought of this, or will take care of this, but it just seems like to me that the work that Pam Notch and you and others and staff have done with respect to this auction, of course, I think the commissioners should get a little bit of credit, because we set it up this way upon recommendation of the staff, but it's really a big success story. And it really, no one really knows about it, and I don't think in the general public, no one's written anything to describe what's going on. I just think it's a real Public Service Commission success story. And I would hope that, of course, there's probably not a reporter in the room, but just hopefully we will make the adjustment you talked about, Doctor, with respect to the timing. We're not going to do it on our own, except for obviously our auction, which I'm sure staff will come to us and make suggestions on. But it really is sort of disheartening almost with respect to what's going on at PJM and the marketplace in terms of the uncertainty. It's just not beneficial, and hopefully the FERC will, and PJM will come up with something in the very near term. So, any questions of Dr. Lidzelter?
Thank you, Mr. Chair. Yes, just one question. Thank you. Very good and encouraging information. Is there anything that that informs us what the future trends look like, or do you attribute to any parameters the reason why we're experiencing more participation and lower costs?
Well, lower costs is certainly a function to a degree of competition, which is also a function of the level of participation. But the underlying market conditions are really what are driving prices. And we're seeing record low wholesale prices in PJM and throughout the country. And a large driver of what's going on in PJM is that PJM's prices are generally set by gas-fired generators. And the price of gas has plummeted over the last 10 years, in particular due to fracking. And this has caused a wholesale, literally and figuratively, change in gas markets which have flown through to the power markets. There is one more factor in the success of Delaware's auction that I think is worth pointing out, though, too, is that Delaware uses an auction platform that I don't know that any other SOS auction uses, and that is the NLX platform. And it performs flawlessly, and it promotes competition, and it does a really good job, and I believe that suppliers like using it, and that also, I think, helps to attract prospective bidders.
Thank you very much.
Welcome.
Drew, any questions?
Okay.
Thank you so much, Dr. Lidzelter. Wonderful presentation, wonderful results. We appreciate your efforts.
You're welcome, and thank you.
Thank you.
Chairman, Commissioners, if I could just ask you to accept the report as final, I would appreciate that.
So moved.
Second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, any abstentions, the motion carries.
Thank you.
Thank you, Ms. Knotts. Number 2 is in the matter of the petition of the Public Service Commission, staff and Delaware Division of the Public Advocate to establish a regulation for distribution system investment plans for Delaware electric and natural gas utilities. I think Ms. Iori is the one I've got at the top of the list here. She's the star presenter on this matter.
Thank you, Chairman Winslow and Commissioners. I'm actually going to throw this off to my client since I have been tangentially involved in this at best.
Good afternoon, Mr. Chair and Commissioners. Proposed Order 9541 would permit the regulations to be published as final. As you may recall, they had been published already for comments. There were no comments, and so this proposed order would publish them as final. So I ask that you please accept 9541. Thank you.
Thank you, Mr. Slater. Tom, Mr. Walsh?
Thank you, Chairman Winslow and Commissioners. Staff also supports Commission's approval of Order 9541.
Thank you, Mr. Walsh, and I don't believe anyone else is present to speak or make comment on this. Gosh, do me a favor, Mr. Slater, just give us a real brief, short, concise history of this particular item that we're voting on. How long has it taken this to happen?
So to get the regulations actually to this point has been 9 months probably. The parties were able to work together and get something before you in about 5 months. As you know, we have natural gas regulations that we're working on. This all came from the DSIC legislation. So it's taken us about 9 months.
Thank you very much. Mr. Slater was very instrumental in getting, I guess, legislation passed, and I I think that this is another success story for the Public Service Commission and the Delaware Public Advocate, and also the Delmarva Power and Light. To get this done as quickly as we did, and make it good for the state of Delaware. I know we had a model in Pennsylvania to sort of look at and learn from, but I would just like to commend everyone involved in the way that they very efficiently and quickly and professionally got this thing done. It was very impressive work, and Mr. Slater, I think you're the one that deserves the most credit, to be frank with you. Commissioners, any questions?
Move we adopt order number 9541 as presented.
I second it.
Is there any discussion on the motion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Number 3, in the matter of the application of Delmarva Power and Light Company for an increase in natural gas base rates. And I believe we have Mr. Geddes is going to lead this discussion.
Happy to lead the discussion, or the company can, however you would like us to proceed.
Well, it's the application of Delmarva Power and Light, and usually we have the presenter at the top of the list on the left-hand side of the document here, so let's have Mr. Skaggs lead this off then.
Thank you, Chair Winslow and Commissioners. This is a settlement of Phase 2 of the rate case, the gas rate case of Delmarva that's been pending for some time. All issues except for the replacement labor cost for the IMU units that were installed by Delmarva once again some time ago. Those costs were placed into a regulatory asset. All other issues in the gas rate case were settled in what the parties have started to term a Phase 1 settlement, which was everything else. As the Commission is no doubt familiar with, the question of whether these costs were recoverable, including issues of whether they were ordinary or extraordinary, and what would be the appropriate standard for a review on them, was subject of litigation before the Commission and before the hearing examiner after the last Commission meeting on this, where the hearing examiner's report on remand had come up, and there was a decision to delay consideration of that report and argument on it until a meeting where all commissioners were present. After that meeting, the parties met, arrived at a settlement, and documented that settlement, and we're back here hoping to get that settlement approved and close out this gas rate case finally and for good. At this point in time, if it's okay, I'd like to put on our one witness. He'll briefly talk about the business decision here to enter into the settlement. I guess we should have Mr. Zeminski sworn.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Zeminski, where do you work?
I work for Pepco Holdings, Inc.
And how long have you worked there?
Over 28 years.
And what's your job there?
I am the Director of Regulatory Strategy and Revenue Policy for PHI.
Okay. How long have you been in that position?
Since the Exelon merger with PHI, April of 2016.
And once again, very generally, and you've given testimony before this commission many times in the past. Is that right?
Indeed, I have, yes.
Okay, and so, but very quickly to refresh the commissioners, what in general are your duties or role in connection with the Delaware rate cases that are filed and prosecuted by Delaware?
Yeah, I oversee the revenue requirements and rate design aspects of our distribution cases as well as our transmission cases at FERC. I do them for all three of PHI's utilities, Delmarva, Atlantic City Electric, and Pepco in all of their jurisdictions. So for Delmarva, Delaware, both on the electric and gas side, I'm frequently a witness, even on the revenue requirement side. But again, my teams oversee the rate side as well as the revenue requirements in those cases.
And in this docket earlier, back I guess we would call it Phase 1 now, did you provide pre-filed testimony?
Yes, I did. Filed direct testimony, supplemental direct testimony in regard to our test period update from forecast to actual information. I filed additional supplemental direct testimony that related to the Tax Cuts and Jobs Act of 2017 and how those were impacted in the gas rates, and then rebuttal testimony as well.
And those, am I correct that those were admitted into the record of this case at the settlement hearing before, in phase 1, before senior hearing examiner Lawrence in September of 2018?
Yes, that's correct.
Okay. So you're familiar with the case and the issues surrounding it?
I am familiar with this case.
Okay. And in fact, you gave live testimony in support of the settlement of the phase 1 portion, is that correct?
Yes, I did.
Okay. And that you understand that all issues except for the IMU battery labor replacement costs were addressed in phase 1?
That is correct.
Okay. Now, today we're addressing the proposed settlement of phase 2 concerning those battery replacement costs. Are you familiar with Delmarva's reasons for agreeing to the proposed settlement of phase 2?
Yes, I am.
Okay. And are you authorized to testify on behalf of Delmarva concerning the proposed settlement of phase 2?
Yes, I am.
Okay. Now, what are and the documents before the commission, but just once again, generally to refresh them, what are the basic terms of the settlement we're asking the commission to approve?
Okay, we're asking the commission to approve the agreed upon amount related to the recovery of the IMU, which stands for Interface Management Unit, labor costs. In total, these costs were a little over $3.4 million. And after negotiation amongst the parties, we agreed to a recovery of 50% of that amount, which was slightly more than $1.7 million. In terms of how that would be recovered in rates, we have proposed and agreed upon that it would be a 6-month increase in customer rates. So rates would go up for each of the classes as outlined in Exhibit A. Those rates increases would be in existence for 6 months, and then we would remove those increases back to what they are today. So,
So could you also give a sense to the commission of what, based on Delmarva's estimates, on what would be the impact on a typical residential customer of the settlement?
Sure. And we typically cite a residential space heating customer. That's the majority of our residential customers and our overall gas customer count. That's one we frequently cite. So for an average residential space heating customer using 83 CCFs, which is 100 cubic feet of gas, which is the average usage, the monthly increase would be $1.59. And on a total bill basis, present bill is about $92. It would go to $92.06 to be specific. That $1.59 increase, 59-cent increase would take it to $93.65, which would represent a 1.7% increase on total bill for that 6-month period.
Okay, so that would just be for the 6 months?
That's correct.
And once again, now, obviously, there were legal issues involved here, and I want you to be careful not to get into any legal advice you received, but could you, once again, generally give the commissioners a sense of the business reasons why Delmarva agreed to the settlement?
Sure. From a business perspective, when we assess a settlement versus continuing to push forward with litigation, we really weigh all the potential factors that are in play. As a phase 2 issue from the gas space rate case, the IMU regulatory asset recoverability has been a difficult and passionate issue for the parties that are in the case. It has gone on for a long time. There's been multiple hearings on this issue, and assessing at where this potentially could go in terms of perhaps additional litigation, depending if that was the path. I think the settlement was a reasonable way to bring the one last open issue in this case to closure. I think that if we look at what continued litigation, both time, distraction, potential costs, not only for the company, but for the other parties, I think we all looked at this as an opportunity to settle this issue and move on and not have it be a distraction anymore. I would point that Delaware law encourages settlements, and as often happens in a settlement, you don't get everything that you want, and I think all the parties that were part of this settlement probably have that same mindset. But I think at the end of the day, it's a reasonable settlement for all parties, and we can essentially, again, be done with the one last issue that remains from this case. So, again, you look at, in summary, the risk of litigation going forward, not just for us, the other parties made that same sort of assessment. You look at what the settlement is, and you assess whether it's reasonable, you assess whether it's in the public interest, and I think this settlement checks all those boxes.
That's all I have. Please answer any questions from DPA staff or commissioners.
Mr. Geddes, any questions? Ms. Iori, any questions?
No, Your Honor.
Commissioners, any questions?
Mr. Chair, I move that we adopt order number 9543 as submitted.
Let's listen to the other parties first.
We'll take that as a good sign.
Well, the problem is that your strategy guy is so adept. It's incredible. He's got that folder there that's about 7 inches tall. It's very intimidating, so that's probably part of the strategy he uses. But Mr. Slater, Ms. Iori, excuse me.
Thank you, Chairman Winslow. The public, I'd like to call Public Advocate Drew Slater to the stand and ask that he be sworn.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Slater, would you please state your name and business address for the record?
Andrew C. Slater, 29 South State Street, Dover, Delaware, 19901.
And who is your employer?
The Division of the Public Advocate.
And what is your position?
Public Advocate.
Now, Delmarva staff and the DPA have reached a proposed settlement in Phase 2 of this case, correct?
Yes.
Were you involved in negotiating that proposed settlement?
Yes, I was.
Could you please describe the terms of that proposed settlement?
Sure. The proposed settlement accomplishes 3 things. First, as Commissioner Gray had suggested when we last discussed this issue in December, ratepayers and shareholders will split the cost of the incremental labor cost 50/50. Second, Delmarva will recover those costs over a 6-month period in rates, and thereafter rates will return to normal. Lastly, while Delmarva will recover half the cost of the total labor expense over a 6-month period, they will not earn a return on those costs.
Do you believe that the proposed settlement is in the public interest and results in just and reasonable rates?
Yes, I believe the proposed settlement is in the public interest and results in just and reasonable rates.
And why do you believe that?
As with any proposed settlement, it's a product of extensive negotiations and reflects a mutual balancing of the settling parties' positions. In short, no one gets what they want. In light of the litigation to date and assuredly additional litigation should this case proceed, the parties propose a settlement in the public interest.
Thank you, Mr. Slater. Mr. Slater is available for any questions that the other parties or the commission may have.
No questions from Delmarva.
Commissioners? No questions from the commissioners. Mr. Geddes has a question, or you're going to take the next?
Like the alligator that's trying to get to the check, I'm trying to move forward here.
Well, please move forward.
Thank you. Mr. Chairman, members of the commission, I'd ask that Malika Davis be sworn, please.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Davis, could you state your full name and business address for the record?
Malika Davis, and my business address is 861 Silver Lake Boulevard, Dover, Delaware.
And you are employed by the commission, is that correct?
That is correct.
And you are the case manager in this docket, is that correct?
Yes,
Are you familiar with the terms of the settlement?
I am.
You've heard testimony by Delmarva and the DPA with regard to the settlement. Do you have any additional information that you would like to share with the commission regarding the terms of that settlement?
I do not.
Can you tell us briefly why staff believes that this settlement is in the public interest?
Sure. As previously stated, this settlement represents a fair compromise between all the parties' positions and will result in no additional money being spent on litigation. This issue was first addressed in a 2016 rate case, so we're several years down the road, and I feel that this settlement represents a good compromise and results in just and reasonable rates for ratepayers.
Are you also familiar with the form of order that's before the commission, specifically order numbers 9543?
Yes.
Does staff support that form of order for the commission's consideration today?
Yes.
Thank you, Ms. Davis. I have nothing further for Ms. Davis. Commissioners have any questions, or the other parties, she's available.
The parties have any questions? Commissioner,
Questions, Your Honor.
No questions.
commissioners have any questions? Thank you, Mr. Geddes. And that's all the participating parties, I assume. Now would it be the time to ask any questions, I guess, or make any motions?
Thank you, Mr. Chair. So before I actually move to adopt this order, I just want to say that I'm very pleased with the outcome of the settlement because in the previous conversations on this matter, my concern was I don't want the company not to move into new technological areas which come with some risk. But on the other hand, I don't want that the ratepayer assumes all the risk if something goes awry. And so this, for me, feels like a very comfortable middle point, and I really appreciate and commend everyone who worked on the effort to get it to this point. So at that, Mr. Chair, I'd recommend or move that the commission adopt order number 9543.
And I happily second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed or any abstentions? The motion carries. Mr. Skaggs, thank you so much, and
Thank you.
Appreciate
Chair
everybody.
Winslow and Commissioners.
have a good day. Next is number 4 on the calendar, which is in the matter of the application of Delmarva Power and Light Company for approval of modifications to its natural gas cost rates. We've got proposed order number 9553 before us, and we have Delmarva Power and Light with Ms. Kurtz-Crompton. Welcome.
Thank you, Chair Winslow and Commissioners. Good afternoon. Dawn Kurtz-Crompton, appearing on behalf of Delmarva Power and Light, or DPL. With me today is Jim Jacoby, who is Manager of Gas Supply and Transportation. The matter before you pertains to DPL's request for a waiver of the requirement to file for an interim rate modification in its gas cost rate, or GCR. DPL filed a letter application on January 21, 2020, setting forth its waiver request, which is being presented to you today for your consideration in proposed order 9553. By way of background, DPL filed its most recent annual application for approval of modifications to its GCR on August 26, 2019. On September 12, 2019, the Commission issued order number 9462, which approved natural gas usage rates, prorated and subject to refund, pending further review and final decision by this Commission. Those rates were put into effect on November 1, 2019. DPL's gas tariff provides that if an under-recovery in the GCR is likely to exceed a threshold of 6% during the GCR year, DPL shall apply for an interim GCR increase. As of December 31, 2019, the projected under-recovery for the 2019-2020 GCR is 7.6%. The most significant driver of this under-recovery is increased pipeline demand cost resulting from recent rate case filings, and other factors contributing to the under-recovery are sales volume and commodity price variances. The combination of these factors has caused DPL to exceed the 6% threshold for under-recovery during the current GCR year. Despite the tariff provision calling for the filing of an interim GCR rate change, DPL believes that such a filing would not be in the best interests of its customers. As set forth in our January letter application, DPL expects that it will receive rate refunds during this GCR period, which will reverse the under-recovery. Consequently, the amount of time, effort, and expense that an interim filing would require of the Commission staff, the Delaware Public Advocate, and DPL does not justify an interim rate increase at this time. In closing, DPL supports Order 9427 and respectfully requests the Commission enter it, approving and approve DPL's waiver request. I'm sorry, do I have the wrong number? 9553, excuse me. Again, we respectfully request that you enter Order 9553, approving DPL's waiver request. Thank you for consideration, and please let me or Mr. Jacoby know if you have any questions.
Thank you very much. Ms. Iori, you're not a
Thank you,
part of this,
Chairman.
right?
I'm sorry?
You're not a part of this?
No, we are.
Okay.
Thank you, Chairman Winslow. The DPA has reviewed Delmarva's request for a waiver of the provisions of the tariff that require it to basically refile its GCR request. We, for the reasons stated by Delmarva, we believe that the waiver is justified, and we would urge the Commission to adopt Order Number 9553.
Thank you, Ms. Iori. Mr. Geddes?
Mr. Chairman, members of the Commission, you have before you the order as well as a memo dated January 23, 2020 by Ms. Gauzy that outlines the reasons why staff supports the company's request in this case. I think that it tracks pretty closely to the comments that you've heard from both Delmarva and the DPA, and staff supports the form of order sorry, I can't even say the right number either. I'm looking at it, 9553. Thank you.
Thank you, Mr. Geddes. Commissioners, do you have any questions of the parties? If not,
Move we adopt order number 9553 as presented.
I second it.
is there any discussion on the motion to approve 9553? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed, any abstentions? The motion carries. Ms. Kurtz-Crompton, excellent job. Thank you. This is your first appearance officially?
I may have appeared officially at a prior meeting with you.
Oh, okay. Okay.
Thank you, Chair, I appreciate that.
Thank you. Number 5 is in the matter of the application of Chesapeake Utilities Corporation for approval of its environmental rider rate, ER, to be effective December 1st, 2019. Who is going to start this? Ms. Orr, please.
Thank you, Chair Winslow and Commissioners. Lindsay Orr on behalf of Chesapeake Utilities. You have before you order number 9554, which changes the date for the evidentiary hearing on Chesapeake's application for approval of its environmental rider from March 4th, 2020 to April 1st, 2020. Chesapeake thanks staff for preparing the proposed order and allowing us the opportunity to comment. Chesapeake's comments have been incorporated in the form of order in front of you today, and accordingly, Chesapeake respectfully requests the Commission approve order number 9554. Thank you.
Thank you, Ms. Orr. Mr. Walsh?
Thank you, Chairman Winslow and Commissioners. Staff also supports the entry of Order 9554. Just to include one quick piece of background, the PSC, the Commission had previously entered Order 9503, which had set a hearing date of March 4th, and that was canceled. March 18th was the new date, and therefore we are renoticing those two dates. But the dates listed in the prior order and attached public notice remain the same. That's why we kept this as short as possible and incorporated the prior order. Otherwise, Ms. Orr's recitation is accurate, and staff supports entry of Order 9554.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman Winslow. I believe that it was going to be scheduled for March 18th, but given that you have all heard about my impending vacation, the parties have very generously agreed to postpone it to April 1st, and I appreciate their accommodation in that regard. Thank you.
I didn't hear about your vacation.
Yeah, I did. We have not heard.
Where are you going to go on
Florida.
vacation?
All over social media.
Really?
Well, it might be if I use social media, but.
Commissioners, do you have any questions of the parties?
Move we approve order number 9554 as presented.
Second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any
Aye.
opposed? Any abstentions? The motion carries. Thank you, Ms. Orr.
Thank you.
And okay, we're now going to go into the hearing schedule. The first matter is in the matter of request for approval of Delmarva Power and Light Company's 2019-20 standard offer service rates, procurement cost adjustment, and RARM filing. We're going to be considering proposed order number 9543, 9545. I think seeing Ms. Kurtz Crompton sit down caused me to have that dyslexic moment. So if you would proceed, ma'am, I'd appreciate it.
Thank you, Chair Winslow and Commissioners. Dawn Kurtz Crompton, again appearing on behalf of DPL. This is DPL's annual application to establish the electric standard office service rates for the period of June 1, 2019 through May 31, 2020. This includes establishing tariff rates for standard offer service supply, the procurement cost adjustment, and the reasonable allowance for retail margin. It is my understanding that the parties are in agreement as to proposed order 9545. DPL thanks the other parties for their efforts in this docket and thanks staff for preparing proposed order 9545 and allowing DPL the opportunity to comment. It is DPL's position that order 9545 should be approved. To get the housekeeping out of the way up front, I would ask that DPL's application and the affidavits of publication, as well as staff's memo, be entered into evidence. Parties have conferred previously, and I believe I am authorized to represent that the parties stipulate to the admission of these exhibits subject to the commission approval.
And the exhibits are admitted.
I have one witness today, Lisa Mothis, that will be providing testimony. May Ms. Mothis be sworn in, please?
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Could you spell your last name?
Mothes. Like mothers without the R.
Ms. Mothis, can you please state your name, your full name for the record?
Lisa Mathis.
And by whom are you employed?
PHI Service Company, primarily on behalf of Delmarva Power.
And in what capacity?
As a senior rate analyst,
How long have you been in this position?
in this specific position, 3 years, but I have been employed by the company for a total of 11, 8 of which were spent in utility accounting functions.
And what is your educational background?
I hold a Bachelor of Science degree in Accounting and Information Systems from Goldie Beacon College.
And were you involved in the preparation of the filing in this docket that was submitted to the commission on March 26, 2019?
Yes, I am primarily responsible for this filing.
Can you briefly explain the purpose of this filing?
The purpose of this filing is to establish the electric standard offer service rates for the period of June 1st, 2019 through May 31st of 2020. This includes establishing tariff rates for standard offer service supply, the procurement cost adjustment, and the reasonable allowance for retail margin. The revised rates include estimates for the projected period plus prior period true-ups for any over or under recovered balances.
And what was the filing composed of?
The filing was composed of revised tariff sheets, a PCA calculation, SOS supply rate calculation, bill impacts, RARM rate calculations, and supporting work orders.
And was the methodology consistent with prior years?
Yes.
In connection with this filing, did you schedule a meeting with PSC staff and DPA to review all of the documents associated with the filing?
Yes, we held a technical conference at the company location on June 13th, 2019, and later answered both formal and informal discovery questions.
And did staff or DPA propose any adjustments based on the documentation included in the filing?
No, neither staff nor DPA has indicated that they found any discrepancies.
Was notice of this application published as required by Order 9371?
Yes, on May 1st, 2019.
And were affidavits of publication filed with the Public Service Commission?
Yes, on May 2nd, 2019, and May 6th, 2019.
And are these rates currently in effect?
Yes, these shred rates were put in effect on a temporary basis effective June 1st of 2019.
And has staff determined that the commission should approve these temporary rates as final?
Yes.
And what is the bill impact to customers as a result of this filing?
A typical residential customer using 840 kilowatts per month on average would see a decrease of approximately $5.24 per month, which is a 4.7% decrease when including the delivery and supply portions of the bill.
And I just wanted to clarify, is that 840 kilowatts or kilowatt hours?
Kilowatt hours.
Thank you. And do you have any further testimony at this time?
No, I do not.
Thank you, Ms. Mathis. And Ms. Mathis is available for cross-examination.
Doesn't appear there are any questions?
No cross, thank you.
No questions.
Any other witnesses?
No, this is my only witness.
Mr. O'Brien?
Thank you, Mr. Chairman and Commissioners. Bill O'Brien on behalf of Commission staff. We do have two witnesses today. Before I call the first witness, I would just like to get into the record exactly what those four exhibits are. The parties did not file in this case an exhibit log, so I did want the transcript to reflect what the four exhibits that we stipulated to the admissibility earlier in the proceeding. Exhibit 1 is Delmarva's March 26th application. Exhibit 2 are the affidavits of publication of notice of the application, the public comment and intervention period, which was published in the News Journal and the Delaware State News on May 1st. Exhibit 3 are the affidavits of publication of notice of today's evidentiary hearing, which was published in the News Journal and the Delaware State News on January 23rd, 2020. And Exhibit 4 is staff's memo, which is dated today and was provided to the commissioners a week ago with the agenda. So I did just want to get that on the transcript. So if I may, I'll call my first witness, and can I have Ms. Jenny Board sworn in, please?
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Your last name?
Board, B-O-A-R-D.
Thank you. Ms. Board, would you please state your name and address?
My name is Jenny Board. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer, and what is your position title?
I'm employed by the Delaware Public Service Commission as a public utilities analyst.
And could you please summarize your educational and professional background?
I have a bachelor's degree in accounting and a master's of business administration. I've worked in the financial industry for the past 13 years, which includes but is not limited to the analysis of various financial documents.
And could you please briefly describe what this particular proceeding is about?
On March 26, 2019, Delmarva filed the application for approval for the 2019 standard offer service rates, including the PCA and RARM. According to the company's worksheet, the annual average monthly bill for a residential customer using 840 kilowatt hours will be decreased by approximately $5.24, or 4.70%. The Commission approved the prorated rates on a temporary basis with proration, subject to refund in order number 9371, dated April 16, 2019.
And was public notice properly posted, and did you receive any public comments pertaining to the application?
Yes, the notice was published on May 1st, 2019 in the Delaware State News and the News Journal. Staff received no petitions for intervention, public comments, or objections before the deadline of June 21st, 2019.
And what was your specific role in docket number 190174, this proceeding?
I reviewed the procurement cost adjustment, rate, and the standard offer service fixed bid price component for this filing. The RARM was reviewed by Samantha Misner.
And what was the nature of your review?
I reviewed the calculations and work papers related to the PCA for the period of January 2018 through December 2018. I also reviewed the SOS fixed price calculations and components of the winning tranche bids, as well as the forecasted megawatt hours to verify the full requirement costs by the summer and winter seasons, rate class, and forecasted billing requirements.
And what are your conclusions regarding the calculations in the application?
I found no errors in the calculation of the PCA or SOS fixed price components.
The fixed price component of the rate is consistent with the winning bid prices that were reported by the Commission's consultant, Liberty Consulting.
So what are your recommendations for the commission?
Because staff did not find any reason to recommend denial of the cost recovery, I respectfully recommend that the Commission approve as final the rates that went into effect on a temporary basis on June 1st, 2019, with proration for the period from June 1st, 2019 to May 31st, 2020.
And is it your opinion that your recommendations will result in rates that are just and reasonable and in the public interest?
Yes, it is. Staff found the rates and tariff changes to be consistent with previous orders.
And the testimony provided by Delmarva Power's witness, Ms. Mathis, earlier in the proceeding, did you agree with her testimony?
I did.
And does this conclude your testimony?
Yes, sir.
Thank you. No further questions. Ms. Board is available if there's any cross.
Are there any questions?
No questions.
Thank you. Staff would like to call its second witness, please, and I would ask that Ms. Misner be sworn in.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name and address.
My name is Samantha Misner, and my business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer, and what is your position title?
I am currently employed by the Delaware Public Service Commission as a public utilities analyst.
And could you summarize your educational and professional background?
I've earned a bachelor's in political science and a master of administration of justice, and I'm currently pursuing my Juris Doctorate degree. I've worked in the legal field for the last 4 years, which has included, but is not limited to, the analysis of various financial documents.
And what was your role in this proceeding?
I reviewed the supporting documents and worksheets pertaining to the reasonable allowance for retail margin, the RARM, and the calculation for the RARM factor.
And what was the nature of your review?
I was responsible only for the RARM review. I reviewed the worksheets pertaining to the calculations for the RARM and the supporting invoices and incremental costs.
And can you briefly describe what the RARM is?
In simple terms, the standard offer service provider, Delmarva, is allowed to recover its incremental expenses, including any carrying charges to provide standard offer service and hourly price service. Incremental expenses include costs associated with cash working capital, uncollectible, sorry. I always do that.
They're going to be telling you that for decades.
Yeah, I always talk fast when I'm nervous. Okay, so incremental expenses include costs associated with cash working capital, uncollectible expenses related to supply, and a profit margin. This charge is embedded in supply rates for fixed price standard offer service customers. It is a delivery charge applied to all hourly price service customers that meet the eligibility requirements. I hate public speaking if you can't tell. I know. Yeah.
What did you find as part of your analysis?
Since the change in the ROM factor exceeded the bandwidth range of a positive negative 5.25%, a new ROM factor was calculated. I did not find any errors in the calculation for the ROM factor, which decreased by 57.51% from the current factor. Again, calculation of the ROM factor, which decreased by 57.51% from the current factor. The new ROM factor is $0.001038, which is a decrease of $0.001405. After the review of the ROM filing, I found the filing to be consistent with prior orders and found no errors.
And what are your recommendations?
I respectfully recommend that the Commission approve as final the SOS rates, which includes, among other things, the ROM factor that went into effect on a temporary basis of June 1st, 2019, with proration for the period of June 1st, 2019 to May 31st, 2020.
Is it your opinion that your recommendations will result in rates that are just and reasonable and in the public interest?
Yes.
And when Ms. Mathis, Delmarva Power's witness, gave her testimony earlier in the proceeding, did you find anything that you disagreed with?
No.
And does this conclude your testimony?
Yes.
I have no further direct, and Ms. Misner is available for cross.
No questions.
No questions.
Commissioners, any questions? No questions. Ms. Iori.
Thank you, Chairman Winslow. The DPA does not have a witness. We do support the entry of Order 9, making sure I'm looking at the right one.
545.
9545, thank you.
Let's get to the 9600s.
Okay, Commissioners, any questions or comments or?
Move we adopt order number 9545 as presented.
I second it.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, any abstention? The motion carries, and the commission wants to thank Ms. Board, Ms. Misner, with respect to their first-time testimony before the commission. And thank you so much, and thanks to Ms. Mathis as well. And I guess we have to thank everyone, right? So Ms. Iori, thank you. Mr. O'Brien, thank you.
My pleasure, Your Honor.
Okay, that will be it for that one. We have the next one is, number 2 is in the matter of the provision of renewable energy portfolio standards compliance charge to retail customers in the service territory of Delmarva Power and Light Company. Ms. Kurtz Compton, please.
Thank you, Chair Winslow and Commissioners. This is going to be a little bit like Groundhog Day, but here we go. Thank you for your time this afternoon. Dawn Kurtz Crompton, again, appearing on behalf of DPL. This is DPL's annual application to revise the electric tariff rates for the Renewable Portfolio Standards Charge for the period June 1 through May 31, 2020. It is my understanding that the parties are in agreement as to proposed order 9548. DPL thanks the other parties for their efforts in this docket and thanks staff for preparing the proposed order and allowing DPL the opportunity to comment. It is DPL's position that order 9548 should be approved. Again, as to housekeeping, I would ask that DPL's, the items listed on the exhibit list, which are number 1, Delmarva's request for approval of Delmarva Power and Light Company's 2019-2020 RPS charge rate calculation. Exhibit number 2 is the affidavits of publication and notice from the Delaware State News and the News Journal. And also the third item, exhibit number 3, are affidavits of publication of notice for evidentiary hearing for the News Journal and Delaware State News. So I would ask that those items be moved into evidence. And again, the parties have conferred prior, and I'm authorized to represent that we stipulate to the admission of these exhibits.
Entered without objection.
Thank you. This afternoon, I have one witness, Monica Miller, that will provide testimony. May she be sworn in?
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Good afternoon, Ms. Miller. Good afternoon. Can you state your name for the record, please?
Monica Miller,
And by whom are you employed?
PHI Service Company, primarily on behalf of Delmarva Power,
And in what capacity?
as a senior rate analyst.
And how long have you been in this position?
3 years in this specific position. I have been with the family of companies for 32 years in various treasury and finance positions.
And what is your educational background?
I hold a Bachelor of Science in Business Administration from the University of Delaware and a Master of Business Administration from Wilmington University.
And were you involved in the preparation of the filing of this docket that was submitted to the Commission on March 26, 2019?
Yes, I am primarily responsible for this filing.
Can you please briefly explain the purpose of this filing?
The purpose of this filing is to revise the electric tariff rates for the Renewable Portfolio Standards, RPS, charge for the period of June 1st, 2019 through May 31st of 2020. The revised rates include estimates for the projected period plus prior period true-ups for over or under recovered balances.
And what was the filing composed of?
The filing was composed of revised tariff sheets, RPS charge calculations, rate change percentage, and supporting work papers.
And was the methodology consistent with prior years?
Yes.
In connection with this filing, did you schedule a meeting with PSC staff and DPA to review all of the documents associated with this filing?
Yes, we held a technical conference at a company location on June 13th, 2019, and later answered both formal and informal discovery questions.
And did staff or DPA have any issues with the documentation included in the filing?
No, neither staff nor DPA has indicated that they found any discrepancies.
And was notice of this application published as required by Order 9373?
Yes, on May 1st, 2019.
And were affidavits of publication filed with the Public Service Commission?
Yes, on May 2nd, 2019, and May 6th, 2019.
Is the RPS charge rate already in effect?
Yes, the RPS charge rate went into effect on a temporary basis on June 1st, 2019.
And has staff determined that the commission should approve these temporary rates as final?
Yes.
What is the bill impact to customers as a result of this filing?
A typical residential customer using 840 kilowatt hours per month on average would see a decrease of approximately 71 cents per month, which is an 18% decrease.
And do you have any further testimony at this time?
No.
Thank you, Ms. Miller. Now, Ms. Miller is available for cross-examination or questions.
No questions, it looks like.
Chairman Winslow, I do not have any cross-examination. Thank you.
No questions.
Commissioners, any questions? Who wants to go next? Mr. Walsh?
Thank you, Chairman Winslow. Staff will call Amy Wiley, but prior to doing so, I will echo my colleague's request that staff's memo also be entered in. I don't know that there be any objection that we were going to include in the exhibit log, decided not to, but I ask that it be into evidence for the purpose of evidentiary hearing.
Ms. Iori, any
No
objection?
objection.
No objection.
Entered without objection.
Thank you, Chairman Winslow. Staff calls Amy Wiley and asks that she be sworn.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Could you please state your name and address?
My name is Amy L. Willie. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer, and what is your position title?
I am employed by the Delaware Public Service Commission as a public utility analyst.
And what is your educational and professional background?
I have earned a Bachelor's of Science degree in Business Management from Wilmington University. I have been employed with the Public Service Commission for over 1 year as a public utility analyst. I also have over 12 years contract sales experience, which included but was not limited to the analysis and preparation of various financial documents.
And what was your role in this docket 190715?
I reviewed the components and calculations for the Renewable Energy Portfolio Standard RPS rates.
And just to correct myself, that was docket 190175. Appears dyslexia has run rampant through the room today. Continuing. And what is this particular proceeding for?
On March 26, 2019, Delmarva filed the application for approval of the 2019 RPS rate charge. According to the company's tariffs, the average monthly bill for a residential customer using 840 kilowatt hours will be decreased by approximately 71 cents, or approximately an 18% decrease. The commission approved the proposed rates on a temporary basis with proration, subject to refund, in order number 9373, dated April 16, 2019.
Did staff receive any public comments pertaining to this application?
No, staff received no public comments opposing the decrease.
And could you describe the nature of your review?
I reviewed calculations, invoices, and worksheets comprising the derivation of the RPS rate. And as part of the RPS rate, I reviewed the recovery of the auction and administrative cost for the 2018 SREC procurement program, which included the Sustainable Energy Utilities and its contract administrator's costs for the period January 2018 to December 2018. Pursuant to order number 8450 dated September 10, 2013, in docket number 12-526, the Commission approved the 2013 SREC procurement program and stated
Delmarva will be required to justify any SEU-related costs above what ratepayers would have paid had Delmarva managed the solicitation itself and had Delmarva not used the SEU as a contractual intermediary. Staff continues to use this as a benchmark for cost recovery. This is to ensure that costs related to the SEU's involvement do not exceed the costs that Delmarva would have incurred if they administered the contracts itself. If the SEU exceeded them, Delmarva would be required to justify any incremental costs.
Thank you. And what did you find as part of your analysis?
After reviewing a significant amount of documentation for accuracy and compliance with prior commission orders, I found no substantive errors. I also reviewed the SEU and its administrative contractors' costs for the 2018 SREC procurement program, and according to the document titled Analysis of Administrative Costs for Delmarva Power and Light Company SREC Procurement Program, January to December 2018, Delmarva estimates the cost for Delmarva to administer the SREC program contracts would result in costs approximately 10% higher than the actual SEU in-climb administrative costs. The cost estimate does not include the capital costs to acquire or develop software to manage the program, nor does it include the cost of running the auction and other auction costs.
And what are your recommendations?
Staff respectfully recommends that the Commission approve as final the RPS charge rate that went into effect on a temporary basis on June 1st, 2019, with proration for the period from June 1, 2019 to May 31st, 2020.
And do you believe that your recommendations will result in rates that are just and reasonable and in the public interest?
Yes, I do.
And does this conclude your testimony?
Yes, it does.
And with regard to Ms. Miller's testimony, do you have any disagreements with anything that she presented?
No, I do not.
Thank you. Ms. Willie is available for cross-examination.
I have no questions.
No questions.
Mr. Chair, I have one question. Ms. Willie, in the staff memo that you submitted on page 1, where you talked about the charge, what the charge is consisting of, there is an item 3 that says adjustment of the qualified fuel cell provider project Bloom on the RPS obligations. Does this mean by the statement adjustment that the qualified fuel cell provider cost is excluded from these calculations?
The offset for Bloom is taken out of the RPS requirements. It does lessen the RPS requirements. And if you'll recall that on the bill, there's actually a charge for Bloom, and there's a charge for what's called the Qualified Fuel Cell Provider Project charge. And there's also a charge for RPS. So this is just distinguishing that the RPS, the charge, and the derivation of the charge has been lessened by the offset of the Qualified Fuel Cell Provider generation that lessens the requirements for RECs or SRECs, but the charge is a separate charge, so that decrease does not take into account any increase or decrease in the Bloom each month.
Okay, so in my simple way of looking at this, this says that the qualified fuel cell charge on the bill is separate and distinct from the RPS obligation.
It is.
Thank you.
No further questions.
Commissioner Korea?
Yes, I move that we adopt order number 9548.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed, any abstentions? The motion carries. Ms. Miller, thank you. Everybody, thank you. That concludes the agenda, right? Okay, we have number 6. In the matter of the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act. Myers, are you going to come up and join us? I would feel very, very much remiss if we didn't have you in our presence. Okay, we're all here gathered together in this, I guess, unique form of Chinese water torture, known as Regulation 56. I'm just going to make a few comments, and then we'll let everybody say something. First of all, there's obviously a difference of opinion on the legal issues, quite apparently. And I guess DENREC and the Public Service Commission have been at loggerheads over the legal issues for quite some time now. I'm not sure how long it's been, but it's been quite some time. Been the source of several court appearances, and I'm sure being competitors and knowing that they're right, that all of the participants have occasionally gotten a little bit upset about the whole situation, which is natural and normal and to be expected. And then we're dealing with an auction, comes up in May, and my understanding is that ordinarily parties to the auction commence work toward and spending money toward the auction approximately 6 months before the auction. We're now in the middle of, that's prompted Ms. Knotts to come forward to sit down. And we're now in the middle of February, so we're not too far away from the actual auction. As far as I know, the Delaware Public Service Commission is in charge of itself and doesn't have any command and control over the SEU or DENREC or really anybody. And, you know, we've tried to resolve this, and it hasn't successful appeal. I tried to give all the responsibility to DENREC. The Delaware Public Advocate appealed, and the court said that they're right and we were wrong. And so now we're in this sort of paper bag with each other, punching each other as two state agencies, which is, in my opinion, a little unseemly and hopefully never again to happen in the future. I also know from talking to various people, and this is obviously not on any record, but that there's legislation going to be offered that is going to resolve this matter and do what this commission tried to do over a year ago, which was give the responsibilities to DENREC, have it all in one agency so we don't fight over all this. Now, Mr. Slater is going to have input on that, so I don't know what the final result of the legislation is going to be, what it's actually going to say, but that's just a factor that's out there. So it's possible that we could go forward and then make a decision and only to have the legislature change the rules of the game on us. That's certainly a possibility. DENREC hasn't shown any inclination to listen to what we want to do. I don't mean that respectfully of DENREC. They've got I think, a firmly held view about what the law is in this particular matter, and they're going to wait until the courts decide the issue. And meanwhile, the courts aren't cooperating with us. You know, we're expecting a decision from one judge back in November of last year, and we haven't heard from that judge yet, and no one's crossing their, you know, we don't know when that's going to happen. We just don't know. And then we don't necessarily know what impact, if we were to start a process that closes the auction down in May, we don't know necessarily what effects that's going to have on the auction. So we're sitting here and we're going to, I don't know what the right answer is, but we do want to have input from everybody involved so that we can make some sort of a decision going forward with this matter, because it's important to the marketplace, it's important to DENREC, it's important to the Public Service Commission staff and the commissioners. So I don't know if any other commissioners want to make any comments, how they feel about the situation, or just want to listen to the input and see what sort of a decision we can come to, if any, on this matter. Mr. Slater, would you, you want to kick it off? Or do you want to have somebody else kick it off?
I'm sorry, were you asking us?
Yes.
Well, it's kind of the commission's orders that have been not complied with here.
Correct.
I would think that it's probably better for staff to kick it off.
Commissioner Gray?
But if you would like us to go first, I'm
Could-
happy
could-
to.
Could we perhaps start as a priority with the attorney for the commission? Do you,
He
do you,
doesn't want to start either.
well, all right, so,
Mr. O'Brien. okay.
Mr. O'Brien.
Thank you, Mr. Chairman and Commissioners. Bill O'Brien on behalf of staff in this matter. Staff certainly appreciates the chairman's comments reflecting globally where we are from a procedural standpoint and the sensitivities regarding the relationship with a sister state agency. What staff is prepared to do today is to comply with the last order in this case. We last met on January 29th in 2020. That's when we last came before the commission on this matter. The commission issued order number 9542, and in that order, the commission directed Delmarva Power to provide commission staff with the cost numbers that it provided to DENREC for REPSA compliance year 2018-2019, as required under commission regulations, no later than January 31st, 2020. So staff is prepared to advise you that Delmarva Power did comply with that directive. Number two, staff, using the cost numbers provided by Delmarva Power, should complete the cost calculations under the existing regulations. I can report that staff has complied with that directive. So we are here today to present those numbers to you if that's the direction you want to go in. If there's a more global proposal out there, staff is certainly willing to discuss that also. If you do decide to move forward with the discussion of the cost calculations themselves that staff has now performed, staff does have a position on whether or not that should take place in public or whether we should go into executive session. Staff's recommendation is to go into executive session, and staff would like an opportunity to explain that position if that's the course that you decide to take, that you do want to discuss these calculations. And staff would like to discuss that staff's position on that for two reasons. One, because it's not the typical reason given for going into executive session that we have here at the commission. And two, we've received 2 email objections from participants in this regulation docket, objections to going into executive session to discuss those calculations. So if the commission decides to move forward with the discussion, then staff would request an opportunity to provide its position on executive session.
I think we're inclined to go forward on the numbers, et cetera, that we, part of the order that you mentioned. I think we're definitely want to do that. I guess the question I have is it really necessary for all the parties sitting around this table to know the underlying facts and circumstances that you got from Delmarva Power, which are apparently, some argument is that it's confidential? Can't we just go to a conclusion with respect to what the results of the calculation were and not get embroiled in the underlying numbers?
Chairman, could I offer a brief statement before you do so?
Yes, certainly. Go ahead.
Thank you. GenRec respectfully suggests that staff's presentation of the calculations at this time would not be helpful. As the chairman indicated, legislation is moving forward that will resolve this and would render a lot of this moot. At the January 29th meeting, commission staff discussed the legislative and court proceedings and expressed that, quote, if there is a development after today that we cannot anticipate at this time that would render it inappropriate to circulate the results, as transcript at 1636 lines 10 to 13. The commission's prior order would provide flexibility not to provide the calculations. As commission staff and the public advocate are aware, legislation is in the works that if adopted would render this process moot. And accordingly, DENREC again urges the commission to decline to have the calculations presented today and urges the commission to provide time for that legislative process to unfold. Thank you.
Chairman Winslow, may I be heard now?
Just a moment, please. I'm not positive I heard all that correctly. you're saying that you don't want, you don't want the underlying mathematics, so to speak, testified about in open court, number one, right?
Correct.
Okay. Secondly, the question is, how about the conclusion drawn by the calculation with respect to the result? In other words, freeze or no freeze?
So in DENREC's view, that it would not be helpful, given that there is legislation moving forward that would render that process and that determination moot if passed.
Well, I understand, but my experience with the legislature is that when you give something to the legislature, they start asking questions. And it's quite likely, if you're going to change the freeze clause in the legislation, that they're going to start asking questions as to what's the present status, what is the present calculation of the present scenario. And so you're going to have a public discussion of this in the legislature. It might be better actually to have a discussion here first and let anybody hear about it ahead of their other discussions. But
So as is the case this year and has been the case in all past years until now, or at least the last several years, that process has not occurred. It has not happened before this commission. It certainly has not happened in public, and so I'm not sure that it would be necessary or relevant to the legislative process. Again, I'm not directly part of that legislative process.
Well, I would think the legislature is going to know what the difference is between A and B. They're going to want to know, under the present status of the law, what's going to happen with respect to the consumers. What are they going to pay for? And under the new law, what's the change? They're going to want to know that. I mean, it doesn't make any sense that they wouldn't want to know that.
I think that the calculation won't be relevant to that determination given the legislation that's out there.
But won't the conclusion as a result of the calculations be relevant and tell them that we're spending more of the consumer's money, that they're going to want to know the impact upon their constituents?
I mean, without getting into the specifics of the legislation, I'm not sure I can address that.
Fine. Ms. Iori?
Thank you, Chair Winslow. I just have a few legal points to make, and then I am going to hand it over to my client, Mr. Slater. But I think the first thing to be said is the fact that there may be legislation that's going to be proposed. The public advocate made that argument to this commission with respect to electric vehicle charging stations. And you all told me by a vote of 5-0 that you didn't know what the legislature was going to do, so you weren't concerned about that particular argument. If that argument applied to me back then, I cannot understand why it would not also apply now. Secondly, the court before which this issue has been pending has not issued a stay. DENREC requested one, but it has not issued. The effect of this commission having not required the numbers to be published has had that effect, and the public advocate thinks that that is wrong. These are public numbers. There is nothing in the statute that suggests that these numbers are not to be made public. And we would therefore request the commission to go forward with, if not the calculation, although we think that is public as well, definitely with what the results of the calculation were. I will hand it over to Mr. Slater now. Thank you.
Before you do that, obviously in the electric vehicle situation, I guess maybe the commission and you were both probably right, because if I recall correctly, the legislature did not act before June 30th. And of course, I'm very aware of the fact that the legislature may not act on any pending legislation with respect to this issue. That's certainly, I hate to say, use the word probable, but it's positively possible.
That it is.
But I think there's a big distinction between the EV issue and this. This is really a much larger issue involving litigation in the Superior Court, possibly the Supreme Court, and it is an interagency battle that's disrupted you know, the scheduling of, possible scheduling of an auction.
Well, actually,
It's just-
I'm sorry, but thank you for reminding me of that. I did want to address that, but
Well, you're welcome to as soon as you can.
oh,
So-
no, I meant you reminded me that I had forgotten to make a point.
No, I got that message. But why don't you wait till, whatever that point's about, why don't you wait till we discuss that point, and then if you want to discuss it now, if it's part of the present discussion, go ahead and discuss it now.
It was, I think you had mentioned, and I may have misheard you, and if I did, I apologize. But I think what I heard you say with respect to the SRAC auction, I think that's the auction that you were referring to in May?
Correct.
The SRAC auction, that this commission doesn't really have anything to do with that, and that's not so. This commission has a lot to do with whether that auction goes forward or not, because it has to be brought forward to you, and basically you have to authorize it. If you don't authorize it, that auction doesn't happen, so you do have a lot of authority there.
Well,
I should say, you do have the authority there.
I guess what I really meant to say was that with respect to the auction, I don't know that we have any administrative or command and control sort of lines between us and the people who are doing the auction. So, you know, yes, we have to do an order. I mean, I understand that, but in terms of commanding people to do things, we're really sort of in a weak position. And it's going to beget more litigation and more argument between some of the parties. That's one of the concerns I have.
What I wanted to say about that too is, unfortunately, I think it's the nature of the beast, the way that our agencies are set up. The DPA is statutorily tasked with representing the public interest, with advocating for the lowest reasonable rates consistent with reliable service. DENREC is tasked with a completely different, actually DENREC's tasked with a lot of things, but they are not tasked with considering the effects of what happens here on consumers. So unfortunately, that is the way it's set up. And sometimes sometimes DENREC and DPA will agree, sometimes they won't. This is one of those times. But I don't think it's unfortunate. I think it's actually probably good that there is disagreement between them on some things. I mean, if we all marched in lockstep, we wouldn't be giving the commission alternative views to consider.
No, I agree with that. Mr. Slater?
Thank you, Mr. Chair and Commissioners. I'll be really brief because I think you hit the nail on the head, right? Whether or not there is legislation in the works, there is not legislation presented right now. And I don't have a crystal ball, and I don't see one around the table. I don't know what the legislature is going to do. But if, as DENREC has pointed out, if they don't want you to provide the numbers because they believe that the legislation will pass, then perhaps they should draw the lawsuit, because that seems like a waste of time and resources as well. Yeah, I think I'll just stop there for now.
If I could just respond to that. The reason DENREC does not want these calculations to be presented is that the calculations the commission has adopted are contrary to the statute. So the calculations that exist in the regulations and the calculations that were advocated by the public advocate and that are now going to be presented are not consistent with the statute. And so those calculations, if presented, are not useful and relevant information, and certainly not relevant to the future.
With respect, I apologize, Mr. Myers and Mr. Stevenson. I do want to hear from you, but I'm just trying to work through some of these little issues we have. To be frank with you, all I see is future litigation. For example, if we're going to go on, and I want to hear what the conclusion is with respect to the situation. I do not feel comfortable making a decision and forcing staff to reveal, or not, maybe I can't even force them to reveal it, but if there's a contested issue here with respect to confidential information, I think that what we usually do is we'll go into executive session. We'll hear before we go into executive session, we'd hear the objection, the assertion of confidentiality. We'd go into executive session, we'd discuss it with the staff. We had to go over the various exceptions, with the confidentiality rules, and we'd make a decision. And then what would happen is, and it's happened in Court of Chancery, is that the party against whom we've ruled, in this case possibly DENREC, would go immediately to the Court of Chancery for a review of that order. Okay, so then, now we're in Court of Chancery, and we're in the Superior Court, and time is now marching on, right? And we haven't come to a decision, we haven't done anything, we haven't marched ahead, we haven't accomplished anything. And meanwhile, we're still fighting with each other. I just don't like that scenario, and I'm trying to find a way around that scenario. And one way around that scenario is to come to, with respect to what's going on right now, which is DENREC is not obeying the order from this agency. Mr. Myers has laid the groundwork with some very good suggestions as to what we should do. I'm sure staff and DP&A, they have also good suggestions that what we should do going forward. And, I think that we should adopt those recommendations as if, we found DENREC in violation and set up procedures so that we follow through. Well, my caveat would be, and I tried to express this the last time we had this meeting in January, is that if I want to kick something down the road, I want to kick it hard. I don't want to come back and argue about this every month. So my thought on it is that we have all these issues to resolve. If we kick the can to July 1st or the first meeting after July, that allows DENREC to get this legislation passed. If they don't pass it, we're ready to go. We're ready to go. We have the opportunity. We have it all lined up, and we're gonna go forward and do the freeze, not the freeze, whatever the facts might be. But we could continue to have this fight, and the commissioners could order that DENREC's in contempt, and they would do this, and they're gonna do this, and the staff's gonna do it because they're not doing it, and they're gonna file something in the Court of Chancery. It just doesn't seem to me to be a very reasonable way to go forward. Okay, that's just me though, so I'm sorry I'm hesitant to express my feelings, but to be honest with you, it's been a difficult, long sludge with this matter, and just, well.
Mr. Chairman.
Mr. Stevenson and Mr. Myers, who wants to go first?
Mr. Chairman,
Yes, sir.
if I may go before they go, just
Yeah,
three
go
quick
ahead.
points. Thank you. And I don't know what role this plays. I'm not going to speak on behalf of my counsel there. Just want to clarify three things. Maybe that might help. First is, yes, staff had discussions on possible legislation, but I just want to make clear when we use the word staff, I take full responsibility. I had a couple of my colleagues with me, assisting me, but it was not a staff position per se, or not a commission position. It was just helping out on technicalities. Just want to make that clear. The second is, you may want to listen to the 4 DAGs out here, or at least 2 of them should know about the reasons why some of this information should remain confidential. And I'm not going to go before that, but I think that's important for you to know. The last
Clarification.
Yes, sir.
Is that publicly listen or in a?
You can, I'll
Or
let
in
Bill,
an-
I'll let Bill answer that, whether you can listen to it publicly or not. But there is a reason that I think is very important for you to know before you make a decision. So, but I'll let Bill come to that
Fair
later
enough.
on. And my last point is, when somebody says that just tell us the result, as an analyst and a researcher, that's very hard to say that tell me the result and I will not worry about the calculation. Any analysis will, the moment you tell the result or reveal the result, will need scrutiny of the calculation or the underlying numbers. So therefore, it is not possible to just say, tell me the result and suppress the calculation or underlying numbers. That would not stand up in any analytical field. Thank you.
Dr. Brewer, I don't know if there's anybody sitting in this room that thinks that the calculation came out that we're going to not have a freeze, okay? I mean, I don't know what the calculation is, but I've been told by Mr. Stevenson and Mr. Myers and everybody, without any type of argument from anybody else from DENREC, that the calculation shows that the freeze should go into effect. That's not an issue as far as I'm concerned. Hopefully it will become an issue and no freeze. I mean, that'd be a perfect solution, but I don't think anybody's espousing that around the table. And obviously, before we do anything publicly, we're gonna do it in private with legal consultation, and we'll make a decision on the merits with respect to whether it's confidential or not. And then we're not gonna announce it publicly. We're gonna give it, obviously, the parties a chance to go to court if that's what they want to do with respect to the order. So this is just a continuation of the litigation resulting from disagreement on the path forward. But let's try to see if we can get together today and get a path forward. So, Mr. Myers.
Can't count me in. I would like right now to speak to the closed meeting session
Yes, sir.
On one small part, and then I'd like to hear Mr. O'Brien's position of why, in effect, an executive session is permissible under the Freedom of Information Act. What's appalling to me is DENREC's statement is, given the pendency of legislation, we should drop a shroud of secrecy around what customers are paying under the present rules and how far above the cap levels that the legislature set in 2010 those costs are. Now, I appreciate the chair's position that the legislatures want to know that information when they go about considering any amendment to the present law. But I think that drops out somebody very much more important, and that's consumers and the public. They want to know what they're paying. They want to know how you're dealing with these numbers and how DENREC was dealing with those numbers. Whether you did the calculations correctly, they want to be able to review, and whether the answer comes out according to those numbers. That's what FOIA does. It opens up your proceedings. It doesn't allow you to, in effect, cast a cloud of secrecy around something you don't want to do because it might undermine potential legislation. I can't find that exemption in FOIA.
Was there something I stated about the procedure we're going to use that you object to? I understand your comments about the position of DENREC.
I just don't want you to go into the executive session about anything. And I object. I'll be glad to hear Mr. O'Brien's, how he lays it out under FOIA, and I'll give you a rebuttal argument, but you just don't have the blanket power to say, we don't want to do this because there's pending legislation. I can't find that exemption.
If I recall correctly, while you were the staff attorney for here at this agency, we had a large utility come in for a rate increase, and there was about 21, 22, 23 issues about confidentiality. And what we did with them is we had an executive session. In other words, they stated the general principles in the open public session, and then we went into executive session to discuss whether or not the applicant made its burden with respect to proving that these things were confidential and could not then be revealed to the public. And we went over them seriatim with staff in the room and counsel for the staff in the room, as counsel for commission in the room. And we made a decision. We made like 23 decisions. It was appealed to the Court of Chancery within the week, and the Court of Chancery upheld exactly what we did, with the exception of one decision we made with respect to something that was allegedly confidential that they approved, and the court said we made a mistake on that one, and they said that was confidential as well. And life went on. We're going to have to address the confidential issue, and if we reveal all the facts and circumstances underlying the request for the confidentiality.
Well, I'm not familiar with that order, and I don't remember ever advising the commission on that. The structure I think you should do, and Mr. O'Brien may have a different viewpoint, is FOIA requires open meetings except if you meet one of the exemptions. I'd like to hear the exemption, and we can argue about that in public. and then you vote in public whether in effect you think it's under the exemption. I just don't see, no one, I'm getting into my argument, but no one claims this is commercially sensitive information. When DENREC had their rules, they published it. They published it for 2 years. They put all the figures and calculations out there on the internet. And most of the information's not commercially sensitive. Delmarva reports all their RPS costs to you, and you publish it. Bloom Energy reports all their costs to you, and you publish it. So it's not a, I want to hear why it's exempt, because it's not commercially sensitive.
Well, that's a conclusion you've come to, Mr. Myers, and I appreciate your conclusion, but the commission can't come to a conclusion without hearing both sides of the issue. And ordinarily, you don't have that argument in public if it's an issue about, and maybe I'm wrong.
I would disagree with that, Your
Go
Honor.
ahead,
I'm sorry
please.
to jump in, but I would
No, please.
disagree with that. That's a legal argument. And, you know, whereas the lawyers are arguing back and forth, it is a legal argument as to whether they meet. And you've identified here 10004, B6, and B4. So you're going to have to look at what B4 and B6 say, and then decide, after hearing argument or without hearing argument, if you don't want to hear it, whether those, whether those exceptions fit this case. But that argument is made in public. That argument is not made so that you only get to hear one side, your counsel.
No, I wasn't suggesting that. I wasn't suggesting that.
Yep.
We're going to hear from both sides. Mr. O'Brien.
Thank you, Mr. Chairman. As I mentioned before, staff is the one who put this notice on the agenda that the commission might go into executive session to discuss the calculations. Staff can support the reasoning for that exception to FOIA. And I believe it's appropriate that we go first, because if you agree with staff's position, there's no reason to make an independent judgment on whether this document meets an exemption to FOIA, and let me explain why. Under the open meetings section of FOIA, there are 9 reasons provided on why a commission can go into executive session. The one that we listed as appropriate here is number 10004B6, which is discussion of the content of documents excluded from the definition of public record in section 10002 of this title, where such discussion may disclose the contents of such documents. And let me explain how staff got to that reasoning. Back in September, this very document from Delmarva that provides the cost numbers for their compliance with the Renewable Energy Portfolio Standards Act, that document was provided to DENREC in accordance with the existing regulations promulgated by the commission. That document was the subject of a FOIA request. Recently, DENREC made a conclusion as to whether that document was a public document under section 10002. That section provides 19 exemptions to FOIA. They found that it met one of those 19 exemptions and did not disclose the document. Under FOIA, there is a process laid out for appeals of agency decisions to protect documents under FOIA. In this case, the first step of that appeal is to petition the Chief Deputy Attorney General of the Department of Justice. That appeal has been taken. So what you have in front of you is a document that we were about to discuss the content of, which has been designated as non-public by a sister state agency, and there is an appeal of that decision in front of the Chief Deputy Attorney General. For the commission to make an independent decision right now on whether or not that document meets an exemption to FOIA would be circumventing the appellate process laid out in FOIA. It's essentially an end run to get around that appellate process. So there is no reason, and in fact staff would proposed that it would be inappropriate to make an independent decision on a parallel track and then disclose it and essentially moot the FOIA process for appeals. So that's where we sit right now. A sister state agency made a determination that's a non-public document. We've been called on to discuss the contents of that non-public document. There's an appellate process that not only includes the Chief Deputy Attorney General, but there are appeals that can be taken after that to Superior Court. So in staff's view, the commission should not now circumvent that appellate process.
So what process will you recommend?
I recommend that this exception, or not the exception, but this one of the 9 reasons provided in 10004 of Title 29 provides that you can discuss non-public documents in executive session. That is our recommendation. We have the order from the last commission meeting where we discussed this. The order called on staff to look at the contents of what we now know is designated a non-public document and to discuss those with the commission. If that's the direction you want to go, that you want to discuss the results of that, we would recommend that we invoke that reasoning under 10002 rather than circumvent the FOIA appellate process and go into executive session to discuss the results.
Mr. Myers?
Well, the person who requested it is me. So, I'm getting whipsawed here. Because Mr. Tweedy, right? I'm sorry, I know your name, I just didn't want to mispronounce it. Delaware turned it down on the basis that it's related to pending litigation. Refusing to give me the document, I filed with the chief deputy. It's in the process. Their response is due next week sometime. And then the chief DAG is supposed to act within 10 days after that, I think. But, and this gets real hairy, they turned it down because I'm supposedly, allegedly, a party to pending litigation, and consequently, I should use a discovery process in that litigation to get the document rather than use FOIA. That's their position. You can ask him. Maybe that's their position in that document. That's a party-specific objection that I'm a party here. I can't have it as a party because I can use your discovery process to get it from you. That's their position of why I can't get it from them. The problem with that is I'm sitting here, but there's a whole bunch of other folks sitting out here that Delaware can't claim is a party to litigation. They're members of the public. And FOIA is enacted for members of the public. And they have a right to hear the numbers, even if you throw me out of the room.
Ms. Ivory?
I would also note that the litigation is before the Superior Court. Mr. Myers is not a party to that litigation.
I have a little allergy problems. Please bear with me if I have a problem.
So if I could speak, DENREC disagrees with the characterization Mr. Myers made. DENREC also does not agree with Ms. Iori's characterization of what litigation it is that we are asserting prevents disclosure. DENREC believes Mr. O'Brien correctly characterized both the state of affairs and the process that is legally appropriate for resolution of a FOIA dispute. Mr. Myers has invoked that process, and that process is pending. It seems wholly inappropriate for an entity other than the Chief Deputy Attorney General, who is responsible under FOIA for making these determinations, to make such a determination.
Chair Winslow?
Yes, ma'am.
I note that the definition of, oops, I just lost it. The definition of public record is, sorry, I had it here. Here we go. Information of any kind owned, made, used, retained, received, produced, composed, drafted, or otherwise compiled or collected by any public body relating in any way to public business, or in any way of public interest, or in any way related to public purposes, And then it has a bunch of things that are deemed not public. The one that DENREC denied Mr. Myers' FOIA request on was, as he said, pertaining to pending or potential litigation. I don't think you get that far. The commission's calculation is its own document. It's nothing that it got from DENREC. It made its own calculation. It is the commission's document. It is not DENREC's document. So it doesn't matter whether DENREC asked the commission, don't make public the numbers that, you got to make that calculation. It's not DENREC's document. What Mr. Myers asked for in his FOIA request was not its calculation. It asked for the numbers that go into the calculation so that Mr. Myers could make his own calculation. But then, after Mr. Myers had filed his FOIA request, this commission asked Delmarva to provide the numbers to staff, which it did, and directed staff to make the calculation, which it did. It is the commission's document.
Mr. Walsh.
Chairman Winslow, as Commission Counsel, I would like to just echo what Ms. Iori said, and it's important to keep the dichotomy here. Mr. Tweedy, and I don't want to misstate what he said, that he didn't specify as to which litigation. I assume, and I can't ask him, but I assume you can ask him if there is more than one litigation. I'm only aware of one. And that involves regulations which are not stayed. And DENREC doesn't agree with those regulations. That's fine, but they're not stayed. And we went forward with a couple of orders that this commission signed, and nothing happened. The Public Service Commission orders were nothing but paper. I don't mean that as an insult. I'm talking about the result. And that was DENREC did not feel it had to obey regulations which were not stayed in accordance with the APA, nor did it have to obey this commission's orders. Therefore, this commission took the appropriate step, I believe, and obtained those numbers from Delmarva, and Delmarva produced those. They were given 2 days to produce those numbers. They produced them the next day. That's under a different order in this Public Service Commission's jurisdiction. That's not a litigation. That's the continuation of a fulfillment of a regulation, and not so much the regulation docket. I don't see that it can't be part of the litigation. And if there's another litigation going on, I'm not aware of it. We haven't received service of process. And if what is to be discussed are Delmarva's numbers provided to the PSC, I think Ms. Iori, as she read the FOIA section, I don't think it falls under that definition of an exception. If DENREC is arguing that it can't be discussed or revealed in any way, shape, or form because it's part of the litigation, I'm not sure where DENREC can make that argument, considering they didn't provide the numbers. We're talking about Delmarva's numbers and the staff's calculations with those numbers. DENREC didn't produce anything. They wouldn't even know necessarily if what staff has is what they have, or in making the calculations, how staff made those calculations, because they haven't reached out, they haven't consulted, and they have basically stepped away from this entire process. And they weren't here for the last hearing where it was ordered that Delmarva provide its cost numbers. So I think we need to keep the avenues clear here. There is the proverbial New Jersey fence, as they call it, that concrete border, and I'm not sure you can cross over between the two. What Mr. Myers is talking about is, I believe, the numbers that Delmarva provided the staff. If he wants to correct me and say, no, I'm just talking about the numbers I'm waiting to get, if I get them based upon the Chief Deputy Attorney General's decision, well, that'll have to wait because we don't have that decision anyway. But we requested numbers under an order that is on a public, or the staff did, under an order that is on the public docket. And Delmarva produced those. I have not seen Delmarva step up and say, we gave those to you, that they're confidential commercial secrets.
We've heard that.
Yep, Mr. Chairman, if I may make a brief.
Okay, go ahead, Mr. O'Brien.
Right, to that last point, there are 19 exemptions. No one has claimed that this is commercially sensitive financial information from the public utility. It's the only thing that's been claimed is what DENREC claimed in response to a FOIA request, which is now on appeal. To the public advocate's point, it is staff's position that we cannot discuss staff's calculations without a discussion of the content of the document provided by Delmarva Power. That document has been deemed non-public. I'm not going to go through that again, but it's on appeal up to the Chief Deputy Attorney General. Now, the reason why we can't discuss the calculations without discussing the content of the document is because this document, it's an Excel spreadsheet. On the summary tab, there's a series of several cost numbers for Delmarva's cost of complying with the RPS requirements. There is also a number for the total retail cost of electricity. The calculation is simply adding the cost components and dividing by the total cost of retail electricity. It's nothing more than that. So one cannot discuss that calculation without discussing the contents of the document itself. There's not any more analysis or any type of soft calculation that goes in. It's just a numerator and a denominator. So it would be impossible in staff's view to discuss the calculations without also discussing the contents of a non-public document.
Chairman Winslow, sections 354I and J of the REPSA specifically refer to the total retail cost of electricity and the cost of compliance with the RPS in the calculations. I think that shows you that notwithstanding what Mr. O'Brien has identified as, quote, confidential or non-public information, the legislature clearly intended that to be public information.
Okay, that's enough. Hold on for a second. Mr. Walsh, now the last time I went through this Donnybrook situation, not in this case, but in another case, we went into executive session. Mr. Michael Houghton sat over there as a lawyer for the utility. You or your predecessor sat over here with staff. I heard, we all heard what the confidential information was. No? You're going to disagree?
That was not a FOIA case. So it's a different
It was a determination.
It's a different argument. Delmarva was claiming that it was commercially sensitive information as to Delmarva. So you can't, the two are not comparable.
No, I agree that the two issues might be different in terms of what, but the issue was confidentiality. Isn't that what they're alleging? Are you alleging confidentiality?
No. Their argument as to why they didn't give Mr. Myers the information was that it was the subject of pending litigation.
Okay, well, then that's what they'll say, and that we have a hearing, right?
I thought that's why we were here.
Well, I mean, everyone's making their argument, but give us advice, which we appreciate, but at some point in time, we're gonna have to do something. You know, absent, you know, so we're gonna do something, I guarantee you that. Mr. Myers?
Let me give you a solution. I proposed it before. The pending litigation exemption is requester specific. As I said, it applies to people who are parties to litigation and are trying to use FOIA to end run the discovery rules in the litigation. The chief DAG several times has ruled that in effect, it's requester specific in that sense. So the two cases involved pending litigation between a prisoner and the Department of Corrections, and the newspaper wanted to see some documents that related to that litigation. And the Department of Corrections' response was, it's related to pending litigation. And the chief DAG said, oh, it might be, but you're not a party to the litigation. The newspaper's not a party to the litigation, so they can get it. Okay, they claim that I'm a party. I don't think I am. I mean, I'm a loudmouth commenter, but I'm not a party to any kind of judicial trial. So if it's specific, I'll step outside. Then the public can hear the numbers. I won't listen. And FOIA is satisfied. Mr. O'Brien?
To you. I'll reply. Mr. Myers may or may not be right that it's party-specific. We're going to find that out soon enough when the Chief Deputy Attorney General makes his decision.
So why not err on the
Okay,
side
that's
of
enough.
public disclosure?
That's enough. Commissioner Gray?
Good afternoon, everybody. So just reflecting on a few things I think I heard right. If I didn't, please correct me. I heard that we're not stayed on this matter by the court. We have an established statute and a past court decision to perform our statutory duty. We didn't get the document under discussion from DENREC, but from Delmarva. So my question to Mr. O'Brien, did Delmarva claim confidentiality when submitting this to PSC?
No, they did not. And that is just one of the many exemptions to FOIA.
So, okay. My view, we should proceed publicly in this matter according to our last order. As litigation or judicial guidance emerges, we should then respond accordingly.
Oh, let's wait a second. Okay, I think I'm going to repeat myself, but I think that maybe some of the comments I made up front, you all have just definitely maybe believe that we're in that position I talked about, which is in a continuing battering, and I see more litigation clearly in the air and another, delay as we go forward. So, I mean, that's what everyone seems to want, so I guess we'll do that. But what we're going to do today, what I like to do today, and if I have 2 other votes, we'll do it, is I like to officially have someone from the DENREC, which will be Mr. Tweedy, I assume, make the assertion of why we shouldn't go, why this should be confidential, and we shouldn't put the information to the public, and we'll hear from the parties, and we're gonna make a public decision. And if there's something that Mr. Tweedy claims is confidential, we are gonna go into executive session, because I'm not gonna let something that's allegedly confidential be let out without the ability of the parties to protect what they believe is confidential. And also have the right to appeal if they don't like our decision. We're not gonna release it immediately because until there's, the appeal period is passed.
Chairman
Yes, ma'am.
Winslow, point of order.
Sure.
There's a motion on the table, and I think
What motion?
Mr. Gray's motion.
No, I shared an opinion.
Oh, I'm sorry.
Okay, sorry.
My apologies.
Mr. Chairman, I have not been able to comment yet.
Yeah, I'm sorry, you can't talk today, Mr. Stevens.
Okay, I respect that because, we're neighbors.
Please, neighbor.
Good evening.
Thank you, thank you.
I know we've been at this for a while. Just a general comment first. Apparently, only DENREC gets to make end runs since they've been doing it since 2012. There is a concerted effort not to make information public. You've got three different pieces that you're dealing with. One is the numbers. Second is the calculation from the numbers, and the third is what you're going to do about it. The numbers are required to be public by the 354I and J. There can't be any dispute about that. You made the point about the legislation that may or may not occur. I spend as much time or more time over at Lake Hall than I do here, so a few insights might help. We've been talking about these problems of confusion and asking the legislature to step in since 2012. And 3 times there has been legislation to increase the amount of the RPS, to extend it. All 3 of those attempts failed, including one last year. There was a draft piece of legislation last year in January. By June, it had still not been released as a bill. It was finally released as SB 181. It extends the RPS, but it does not address the cost cap. That is the only bill in front of the Senate Energy Committee at this point. The proposed bill is still in draft stage, and there is a lot of argument going on because of the details in that bill. And it's not me arguing it yet. I will be, but within the administration. So there is no guarantee that a bill is going to be passed. And if you're waiting for that, you may wait forever.
Isn't the issue, though, from my point of view, whether or not we're going to fight tooth and nail until July 1st, or are we going to reach some sort of a compromise position where we can go forward, knowing that on July 1st, if they don't get the legislation passed, they got to stop stonewalling us and do what they're supposed to do according to our rules and regulations?
In due respect, we said that last year. And at the end of June, there was no bill. So we're just going to do it again. My suggestion to move forward is to go ahead in public, show the numbers, show the calculation, and if it determines from that there should be a freeze, do the freeze. If you do the freeze, it's a slap in the face to the legislature to do something. And only the legislature, I agree with you, is going to solve this. But they've avoided it for 8 years and unsuccessfully tried to deal with it. A freeze will wake everybody up, and then we'll see what happens. I think there's another piece to this. You've mentioned, Chairman, that this has broad implications. Let me disavow that. The only impact, there's 2 impacts of a freeze. The first one is Delaware will no longer be supporting out-of-state wind farms with REC purchases. I don't find that to be a serious issue personally, particularly since Woods Mackenzie, who is probably one of the best renewable energy analytical corporations in the world, announced that in 2018, 81% of all the wind and solar built was built outside of renewable portfolio standard mandates. RPS mandates are 2-decade-ago answers. What's happening today is there is a very competitive market. Within Delaware itself, this year, and don't ask me to, I've heard pieces here and there. There may be as many as 15 utility-scale solar operations being planned this year. Solar has gotten to the point where it's actually cheaper than existing generation in some cases.
Mr. Stevenson, please, we have been here a long time, and I appreciate your forward thinking with respect to the solar industry. You mentioned the wind farms too. That I just read that they're 10% of American energy is coming from wind farms now. So
correct.
All that stuff is great, but I'm just trying to decide how to move forward with this evidentiary hearing.
Well, okay. So as I said, the way to move this forward is to go ahead and if there's a freeze, make a freeze, and that'll get the legislature moving. Second thing I've got to say it, I'll take a minute to say it. I've been doing this, I've been in front of you for 9 years. You've been gracious enough to put up with me till today when you tried to stop. But what I've seen is that the PSC is, I admire you guys. You have a difficult job. You have shown professionalism, you have shown transparency, and you have shown integrity. Now, this is my opinion, but in my opinion, DENREC is casting a shadow over the, and a pall of secrecy over this because they don't want the public to see this. It is, and another word for that is cover-up. I would not want to see the Public Service Commission damage your integrity and your professionalism by aiding and abetting in any way a cover-up. And I use that term after a lot of thought. It is not, I mean, an allegation like that is a big deal, but it is a cover-up. They do not want the legislature to see what the costs are. You said very early on that the legislature needs to look at what is the cost cap calculation based on your regulation, and DENREC is very welcome to go into a Senate hearing or a House hearing and say, this is the calculation under our rules. And I think you'll find that doing it either way would result in a freeze. So I would encourage you, get this done publicly. If it's a freeze, make a freeze, and then you'll get out of this logjam. Thank you.
Okay, we're gonna take a 5-minute break, and we're gonna be back, and we're gonna hear from Mr. Tweedy, and he's gonna make his comments on behalf of DENREC, and we're gonna hear from each party in opposition, and we're gonna make a decision publicly, and part of that decision maybe we'll go into executive session. We don't know. But-
Chair Winslow, what are we going to be arguing?
Well, I think what's
Because I don't think any of us were prepared for this today.
Okay. I think we had an order, as Mr. O'Brien stated, that said that Delmarva Power was supposed to provide the numbers. That happened. The staff was supposed to do the calculations. That happened. And then, obviously, we were gonna come to a decision about what to go do next in terms of, I guess, if DENREC was gonna consult with us or not, which doesn't look likely. And also the discussion about revealing the numbers, okay? So that's where I think we're going. And in that process, if DENREC makes an argument with respect to certain information being confidential, we have to hear that issue as well. And then may go into executive session on that. I say may, we may not. But if we make a decision and we say it's not confidential, we're not gonna require, my vote's not gonna be to require staff to reveal the numbers immediately without having DENREC get the opportunity to appeal our decision.
Well, I guess I'm a little confused because DENREC hasn't claimed in front of you today that it was confidential.
Well,
I mean,
if there's no, he's got I've heard the word confidential, I've heard it.
You've heard it from your own counsel. You haven't heard it from Mr. Tweedy.
Okay, well, Mr. Tweedy will make that representation, then we have to deal with that, right? If I'm mistaken about what the future evidence is, I apologize, but if he doesn't make any answer, then obviously we'll have an easy job, right?
Well, I guess my point is this, that none of us came prepared, I don't think, to discuss confidentiality. I think it's kind of a little unfair to all of us to do it on the fly. I understand that you want to hear that, and I certainly don't want to put this off. So I will make the best argument that I can based on, what I can pull out of my head at this point of the day. But I want it on the record that I do object to this procedure.
Okay. Do you have an alternative procedure you want to recommend?
I think the alternative procedure was what was laid out before you. You've already heard what staff's position is on whether it is confidentiality has not been argued by anybody but your own counsel, and that was in relation to whether you can go into executive session or not.
Okay.
It has
so-
nothing to do with whether the document itself
Okay, so
is
we're
a
gonna-
confidential document.
We'll take 5 minutes, and we're gonna come in, and people can express themselves with respect to the step forward, and we will decide what the step forward is after we've heard from everybody, and well, actually, we can just discuss it publicly amongst the commissioners and get going, right, Joanne?
I have something to add, please, sir.
Please do it.
On January 29th, in order number 9542, which was adopted by this commission, under now therefore by an affirmative vote, etc., number 3 says that staff present the cost calculations to the commission at its February 19th regularly scheduled meeting. I'm sorry, I forgot to put 2020, regularly scheduled meeting, with its conclusions as to whether such calculations indicate that the REPSA cost thresholds relating to the freeze determination have been exceeded for consideration by the commission and consultation with DENREC if DENREC chooses to participate.
I think that she's absolutely correct. The only thing I would add is the fact that DENREC has a subsequent objection to that procedure, which is gonna put on the record when we come back in 5 minutes.
Well, I would say,
We're
Your Honor,
gonna
that
take a
is
five-
what's
we're gonna take a-
before you.
We're gonna take a 5-minute break.
Yeah, it was my response song at Ashford. I didn't say what the name of it was. I said it wasn't a FOIA case.
Hey, how are you?
I want to know if you and Lori made the shopping together.
No, but we talked at the meeting to just like, we did, we planned it.
Okay.
It's planned.
Okay.
Yeah, we need a picture.
Oh, the two of them.
We planned it.
I just thought everybody needed a break.
You did the right thing, with the break and everything, and you explained it again and again, so you were right there. So, do you have any leftover? Only one.
All right, I put it off.
Anyway, I'll see that.
You see the new one? A new machine?
I have a sticky note, like, a lot of things.
I haven't either.
Commissioner, there's a notice that the school is not allowed in the school.
How are you? No, the machine. What happened was the inside machine was because of security. I put one in, and then we were just saying we need a better dining area. So I said, okay, call these guys up, tell them to put the machine outside, there's no public here, and also get us a nice machine like it's upstairs. They have the card sitting. So the guy was came today. He felt better because he now has more business.
Thank you very much.
Big area, right?
Good luck.
I want to see you. Happy birthday.
But Dr. Baruch won.
I did. You did?
Yeah, one of my favorites, yeah.
Oh, yes.
Yes.
Thank you. Yes, violation. Whoa. Commissioner order.
We're all in it.
Rep.
We're all in it.
And you need that in the public.
Yes, in the camera. But, excuse me, have you seen the sign?
Yes, sir.
Ask two votes. You got two votes. Why? No, you don't count. You don't know when to keep quiet. You talk too much.
But guess who
You-
ain't talking to
Wait. Do you understand what 5 minutes means?
I do.
What?
It needs 5 minutes.
When you're driving from Newcastle to here, at the 30th minute mark, I have to stop. That's what 5 minutes means. Just say it.
Nobody leaves like that. And there it is. We said, no, this, put that together with the legal problem. Yeah, yeah. No. Sorry.
You gotta be
Yeah, well, I came back especially for this.
You have to, everybody has
It's
to be
in there,
ready.
it's in
And
there.
then we get everything a week before. You have to, you know,
Yeah.
understand everything.
It's, I mean, I wish the legislature.
We're moving at the speed of
Light?
light.
I mean, like,
Yeah.
come on, it's just at some point, it just gets crazy. Yes. Just do something. If somebody just does something like that, you know, that's.
No, Raj, this is not what I meant. No, the actual,
Now my computer's not able.
Oh, she was reading from. Okay. Yeah. Oh, that applies to today.
Yes,
The
yes.
things that have to be done today. All right.
Yeah, that was the old one.
Huh? Last meeting's over. Yeah, I'll go get it. It was five.
Oh my gosh, it's cold.
Give me 5 minutes.
Seriously, that, about must get fixed. Oh my God. It's shot. Yes. You can't even get your mouth down on it. Just shit's straight wrong. Because they're gonna have mold issues and all this.
Basically, the order that applies to what she was reading. It's on the screen, actually. Here.
I'm sorry?
Just fine, thank you. Still cancer free, no chemo.
Just read it off to me, I'll just write it down.
Order number
9542.
Yeah, sure.
Yeah.
It says that get the information from DPL.
Oh, you wanted the action items. Here, you can read it.
Really, what's right there, what you need?
Oh, okay, all right. Commission directs Delmarva, Commission directs DPL to provide staff with the numbers.
What's that?
Number 2, staff uses the numbers and completes the calculation.
Yep.
Number 3, staff provides the calculations to the commission today with conclusions about the freeze or no freeze. And the tail end of that sentence says, for consideration by commission and consultation with DENREC, if DENREC chooses to participate. That's it. It's right here.
We met him in Alexandria Friday.
Okay. Let's find all this.
Maria, are you okay? Did you need anything?
Good, thank you. All right, I appreciate it.
You back already, Bill? Harold's already back. What's this?
Public comment session at 5.
She's going to fall apart because you don't have no break.
Sunday, I have a wedding on Saturday in Philadelphia. I have a nephew getting married.
Is London hot?
No.
No?
Something happened to my little piece of wood. Donna's not back yet, so.
I thought you had an office camera. Nice one. Oh, I thought you purchased it. Surplus. Surplus.
Yeah, thank you. Let's get back into session, please. Okay, thank you all very much. Mr. O'Brien, I believe you've stated for the record that pursuant to the order number 9542, executed in January, on the 29th of January, that Delmarva Power and Light had provided the staff with the information necessary to do calculations, correct?
Correct.
And did staff then utilize those numbers to do the calculation that the statute indicates, or not the statute, we'll say the rules and regulations indicate the DENREC should do?
To the best of its ability with the numbers that it had, yes.
Were you missing numbers?
Yes, but we believe that it can still be discussed in a substantive way.
Okay, so we're now at the point in time where I'm going to ask Mr. O'Brien to provide the information with respect to the cost calculations. And Mr. Twitty, you have an objection you want stated for the record?
So DENREC, as has been stated, Mr. Myers has requested various documents from DENREC via FOIA. DENREC did not comply, citing exceptions to FOIA, particularly including the pending litigation exception. FOIA includes, among litigations before quasi-judicial agencies such as this, and this is certainly a litigation proceeding, if there ever was one, that Mr. Myers and DENREC are both parties to. I would like to make a couple other points. The calculation that the Commission has put in its regulations, and that I'm sure has been aptly done by Commission staff, is incorrect, as stated in REPSA. The statute does not contemplate the calculation that has been included in the Commission's regulations, and therefore whatever the results of those calculations are, those will not be useful or helpful to the public in understanding whether and how REPSA is succeeding in its purpose. I think it's also very important to realize that REPSA is succeeding in its purpose. Renewables such as wind and solar are a much greater percentage of our energy feed than they were when REPSA was enacted. And just today, on the docket, was a discussion of how rates are, I believe, the Liberty Consultant said that they are at record lows. And in fact, Delmarva was here before the Commission to get a reduction in its RPS compliance tariff. That is, that the costs for RPS compliance had gone down 18% year over year. So it is very clear that REPSA is achieving its purpose and that costs are falling. The FOIA has a process to resolve disputes over whether or not information is a public record that should be turned over in response to a FOIA. Mr. Myers has engaged in that by challenging DENREC's decision to the Chief Deputy Attorney General. DENREC will respond, and the Chief Deputy Attorney General will determine who is right. That is the process that is established in the FOIA statute. The Public Service Commission does not have a role in resolving disputes over FOIA. So to the extent that what this is about Mr. Myers' request for records from DENREC, that is the process, and that is the process that should happen. Both Ms. Iori and Mr. Stevenson asserted that sections 354I and J of REPSA require these numbers to be public. That is simply not accurate. Anyone is welcome to read those provisions of the statute. Nothing in there requires those numbers to be public. As a final point, DENREC continues to believe and believes that the courts will agree with DENREC that this commission does not have the unilateral authority to issue a freeze. And so if that is the road that the commission chooses to go down, as Your Honor indicated, this undoubtedly is not the end of this dispute. Thank you.
That's the truest thing I've heard today. Mr. O'Brien.
Mr. Chair, may I interrupt for just a second, please, for clarification from, so I heard the question, did you object to Mr. O'Brien's disclosure of Delmarva information for the calculation information? Your response, in what I heard, was about disclosure of Mr. Myers. So what about your objection to Mr. O'Brien's disclosure to this commission?
So DENREC's role in this is that we received information from Delmarva. Separately, Mr. Myers sought a variety of information from DENREC. The FOIA statute provides, and Mr. O'Brien provided the reference to it, provides a list of exceptions to what is a public record. Among the items that are accepted from being a public record are items that relate to pending or potential litigation. DENREC asserted that the records are relevant to pending litigation, namely this proceeding, and therefore cannot be disclosed.
Mr. O'Brien.
Mr. Chairman, staff's position, as we stated before, is simply that the commission should not take a parallel track to deciding whether this document is a public document or not. That process has already been instituted, and as Mr. Tweedy said, they've got a brief or a response that's due soon under some sort of procedural schedule, and then at some point, the Chief Deputy Attorney General of the Delaware Department of Justice will make a ruling on whether DENREC appropriately withheld this document that we're here to discuss today. So it's staff's position that until that position is overturned, until the designation of this being a non-public document is overturned, the commission should respect that process and discuss the contents in an executive session. Staff's position is simply that you can't discuss, it would be difficult to discuss the conclusions without referring to the contents of the document, since the contents are very simply put, several numbers that are added together and then divided by another number. Certainly, if the commission wants to make a determination that, well, let me just leave it at that. The staff position is that we should discuss this in executive session. If the commission decides against that, then we're prepared to discuss it in public.
Ms. Iori.
Thank you, Chairman Winslow, Commissioners. I think the FOIA issue here is a red herring. The question is not what Mr. Myers may have asked DENREC for. The fact is that staff did not get the numbers from DENREC. It got them from Delmarva. Delmarva did not assert any limitation on the dissemination of said numbers. Staff then prepared its calculations. And all the things that I have heard today, what I have not heard said is that staff considers its calculations also to be confidential. So to me, the answer is whether the commission is going to follow the order that it entered on January 29th, at a time when it knew that Mr. Myers had filed his FOIA request to DENREC, and I'm not sure if DENREC's response to that request had occurred at that time. But certainly on January 29th, when the commission issued its order directing Delmarva to provide the numbers and directing its staff to make the calculations, the commission knew that about Mr. Myers' FOIA request to DENREC. Thank you.
Thank you. Mr. Myers? Same comments as before?
Please pull the mic.
My only comment is this. Why do you have to keep them secret? I mean, I just don't see, regardless of all the law, we'll go back to the chair's position in the beginning, regardless of all the law, why is this shroud of secrecy around these numbers? DENREC says, well, they'll be misleading. Well, it's a marketplace of ideas. We put those numbers out there, they say they're misleading, but at least they're out there, and they're not hidden from anybody. I mean, I don't understand why the commission believes it has to deal with this matter in private. The executive director said that there were reasons. Maybe there are. But I just don't see them.
Mr. Stevenson?
Yes, very quickly. Whether 354I and J state that the numbers are going to be public, DENREC has already established a precedent by publishing the numbers in the past. So there is no reason for secrecy here.
Mr. Slater?
Thank you, Mr. Chair and Commissioners. I have one comment, and you had mentioned it earlier, so I won't belabor the point. But you had said, whether the number comes out now or in the legislature, if a legislator asked you for the numbers, you would provide it. Just like if a legislator asked me for the numbers, I would provide them with the numbers, because the numbers aren't themselves confidential according to Delmarva Power, which is whom provided the numbers to begin with. So I'm just saying, if a legislator had asked you for it, then what's the difference between a legislator or a customer of Delmarva Power?
Mr. Walsh, no, thank you, not right now.
I think there's an important point that I would like to make
Well,
for the Commission
you're not one of the
Council.
parties, Mr. Walsh. You are a lawyer. If one of our commissioners has a question, I'm sure we'll ask it of you.
Well,
Thank
then
you.
I will not advise on the law.
No, that's not the point. The point is that you are interjecting yourself into the argument, and no commissioner has asked a question. Now, I understand you think it's important, and I respect your legal ability, and I respect your opinion very much, but you've already opined on these issues earlier, if you recall.
I did, Chairman, I was not adding to the argument. I was just reflecting the fact about the previous order and the effect that the decision today will have on that. But
And you did mention that before. You said it would be holding our papers meaningless, or words to that language. You did talk about that before. Okay, we've heard from everybody, okay? Any commissioners have a question? Commissioner Gray.
For Mr. Tweedy, is there anyone else sitting in this room who happens to be viewed by DENREC as not able to receive this information? Because I do recall an offer made earlier by Mr. Myers that he would step out of the room, and perhaps that.
Commissioner Gray, the room is a very large room. We're on TV. People are watching us as we speak.
No, I understand that, Mr. Chair.
Well,
I'm only asking Mr. Tweedy if there's anyone who occupies the same restriction as Mr. Myers.
So it's very hard to answer that question because from DENREC's perspective, this requires following the requirements of FOIA. And FOIA has specific requirements that come into place when a FOIA request is received, as DENREC received, and that's what we are dealing with vis-a-vis Mr. Myers. So I can't really speculate on other those other contingencies. The second half is the open meeting requirements, which are the requirements that Mr. O'Brien has given you guys guidance on, which apply to you as opposed to the FOIA request, which came to DENREC.
Now, with respect to the decision here, I'm just going to express my personal opinion. Ask other commissioners to be frank with you. I believe that Ms. Iori has hit the nail on the head with respect to the issues surrounding the calculation and its that procedure. So I would be inclined to continue forward with the presentation of the continue forward subject to any a further objection, which I think we're going to hear. But I believe that Ms. Iori has stated that, and Mr. Myers have that's my feeling. Other commissioners, how about yourselves? Ordinarily, we obviously give great weight to what staff believes and what their lawyer says, and great weight to what Mr. Wall says as well. But I believe that the information should be public and that we should reveal it publicly.
I concur, and the reason is that, and please correct me if I'm wrong, Mr. O'Brien, when those numbers were provided by Delmarva, were they provided under a confidential cover?
Commissioner Drexler, they were not, and it is staff's position that is not dispositive of the issue, because there are many exemptions to FOIA, and this one has to do with pertaining to potential litigation, and that's not Delmarva's bag, it's DENREC's.
I have one more question for Mr. O'Brien. Mr. Tweedy indicated that and I'm not quite sure if I'm getting this right, that either the process or the figures were inconsistent with the statute.
Correct. That the
Figures or the
calculation.
process? I'm sorry.
We have no reason to dispute the actual numbers that came from Delmarva. We dispute the formula that results in the calculation that was put into the commission's regulations and that staff has undoubtedly utilized.
So that goes back to the regulation, not that you might argue is wrong in your opinion, but not necessarily wrong pursuant to the regulation or statute.
Correct. We believe it is wrong, and that's why we're in Superior Court litigating that issue.
Okay. And one more follow-up question with Mr. O'Brien. You indicated that the information that was provided to you from Delmarva may have had some missing or wrong numbers? You didn't say that specifically, but is that correct?
Not that they're wrong. There are certain numbers for that delivery year that would need to come from DENREC, and we don't have those numbers, but we certainly have, well, we don't have all the numbers. We do have some of those numbers that are supposed to come from DENREC because they're public information. So in staff's view, we can substantively discuss the calculations even though we don't have those exact numbers, because we know order of magnitude of what they are.
Thank you. I have no further questions.
Commissioner Drexler, if I may just piggyback on Mr. O'Brien's answer. Just so you understand that the missing information from DENREC, so what we have done is use proxy numbers.
Right.
So therefore, the result could be challenged. Now, to what degree, we don't know. But I just want to, as an analyst, that is a proxy number. That's not the, actually, I think that's what Mr. Tweedy was alluding to.
Right, and that goes to substance, and you're saying substantively, we're going to get a good indication from you today.
That, yes, but to Dr. Barua's point, if that engenders a point for challenge or appeal, then we would have to deal with that.
Thank you.
Commissioner Correa.
This is for Mr. O'Brien. If we go into executive session and discuss the figures, then we decide that we want to make it public. So we come back and make it public. Is there still those contentions valid?
The staff's position would still be intact. Now, clearly, once the commission decides in a manner inconsistent with staff's position, then staff backs off. Then it's up to DENREC to make any challenges.
So there is a potential of legal issues. Potentiality exists, right? Be-
Well, yeah, there are appellate processes on both sides of the equation. When now, if they are disclosed publicly, then the cat's out of the bag, and we haven't discussed how that would unfold for DENREC to have a challenge to something that's already out in the public domain. I'm not sure how that would unfold. But certainly, in the context of the process laid out in FOIA, if the Chief Deputy Attorney General makes a finding that DENREC incorrectly protected the document, DENREC has appellate privileges also to Superior Court. But that would not unfold in that way if we disclosed it here today, because it would already be out in the public domain. You'd have to ask DENREC what their next step would be.
Thank you.
Commissioner Conaway.
Mr. O'Brien, you said there are invalid or incomplete numbers that were provided by Delmarva.
Well, Commissioner Conaway, I wouldn't put it that way. Delmarva gave us the numbers that they were supposed to give DENREC and did give DENREC. It's just that the total cost of compliance includes certain numbers that come from DENREC.
But the order from the 29th of January says that staff, using the cost numbers provided by Delmarva Power, complete the cost calculations.
And it's our opinion that we have done that.
All right.
We've completed the cost calculations to the best of our ability.
Okay.
And with numbers that, in our opinion, are close or at least order of magnitude, enough to make a determination on whether they exceed the cost thresholds, the cost cap thresholds, but certainly not the numbers called for by the existing regulations. And in fact, we're already outside the existing regulations. This was for DENREC to do, not for staff. So we've already gone beyond the existing regulations.
I move that the commission find in favor of Ms. Iori and Mr. Myers with respect to the objections made by DENREC about the public disclosure of the calculations, and would ask that someone second that motion.
I second that motion.
Is there any discussion amongst the commissioners on that motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Okay, so right now, we're in a situation where, you know, the commission would like to know what the result of the calculation is. As I understand the comments around the table, staff feels somewhat at unease with respect to that because of the things that Mr. O'Brien had mentioned. Obviously, Mr. Tweedy, on behalf of DENREC, does not want the information to come out for the reasons he stated. And of course, I think that Mr. Stevenson and Mr. Myers and Ms. Iori have been pretty clear as to what their position is. And what I move is that the staff provide the commission with its conclusions with respect to the calculations and indicate that the reps to cost thresholds relating to freeze determination have been exceeded for consideration by the commission, and we'll get to consultation after that. Did I make a motion, or I just sort of talking to myself?
Yeah, I second that motion.
Okay, I'm sorry. It's been a long time. Okay, Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Anybody opposed? Any abstention? The motion carries. Okay, so now we've gotten to the consultation. Mr. Tweedy, we're going to ask Mr. O'Brien to provide us with the results of the calculation. I don't intend to ask him for anything further than that, but other commissioners have the right to ask the questions they feel is appropriate. Is DENREC going to consult with us with respect to those calculations today, or you risk to do that at another date, after you've gotten more input from your superiors?
DENREC staff are not attending this meeting today, as they do not view this stated consultation sought by the commission as appropriate or in compliance with the statute. DENREC continues to oppose this commission process and objects to any determination to a freeze to the renewable portfolio standard requirement. DENREC has expressed its position in detail before, and I will not belabor those now, but the commission is well aware of DENREC's objections, which include that these regulations, which include that the calculation required by the PSC regulations predetermines the outcome by improperly including amounts such as the Bloom energy cost in the calculation. And this purported consultation, which replaces the authority plainly granted to DENREC by the statute with the authority of the commission to make a freeze determination, is at odds with the plain language and the intent of the REPSA statute. DENREC therefore opposes any determination to freeze the RPS requirement, which the commission may attempt to make today, and preserves its legal rights as to that. DENREC also notes that it seems wholly unnecessary as a matter of policy to be pushing forward with this effort. As was stated earlier today in a separate agenda item, RPS compliance costs have fallen in double digits year over year in the most recent compliance year. And as I believe I heard correctly in agenda item number 1 on the docket today, costs are at record lows for purchases. Thus, there is absolutely no need to institute a freeze. DENREC yet again urges the commission to de-escalate this interagency confrontation by staying its hand and allowing the legislative process to unfold. Thank you.
Thank you, Mr. Tweedy. Mr. Slater, you had something you want to say?
Yes. So the reason that the wholesale price has gone down, as we heard earlier, was because natural gas cost $2.15, according to Henry Hub. The reason renewables have gone down is because of really expensive long-term contracts that were really bad, that have come off of the books. It has increased in years prior, and we have not heard an opposite argument from DENREC.
Well, we did have a good day today for the consumer. To me, my count was about 4 different decisions today that save money for the consumer, but that's not.
Mr. Chair, that's what I would call a balanced agenda.
So would I.
Okay. So you don't want additional time with respect to the consultation issue
DENREC is not participating in the consultation today.
today?
I have no knowledge of any further consultation. This was the item that had been placed on the commission's
Okay,
order and
that's-
agenda.
That's fine, I understand. I mean, that's been, clear, I think, from the beginning, but our urge to argue is very strong. Okay, so, commissioners, I don't know if I made the motion or not, but I did, okay, so all those in favor of the motion signify by saying aye. Aye. Oh, we did that already. Okay, so Mr. O'Brien, I'm sorry, I'm losing track here. Would you be kind enough to have Ms. Knotts ask her some questions with respect? And I think I was careful in my language. I didn't ask you to get into the underlying nuts and bolts, but rather just the conclusions?
Very good, Mr. Chairman, and if it pleases the commission, we will start with the highest level conclusions, and we can move down as far as the commission would like.
Please proceed.
Do we want to swear her in, or just?
Just point of clarification. So if I understand the proceeding is where we are, I think you want to move down to the layer that doesn't really pierce what Mr. Tweedy is concerned about. But I think you want to give the commission clearly the outcome and conclusions from your calculation work.
Yeah, he said he's gonna start at the highest level.
Well, right, I'll start at the highest level. I mean, staff's position on the record is that the highest level pierces the confidentiality that DENREC has invoked, but that we've already gotten past that. We're gonna make these public. So, I mean, but I do understand you don't necessarily want to go down as far as unnecessary for purposes of today's discussion. So I'll
Correct.
start at the top. So, I don't know, we didn't discuss this. Would the commission like Ms. Knotts to be sworn in?
I don't think that's necessary.
Okay. Ms. Knotts, as you're aware, Commission Order Number 9542 directed staff to present cost calculations with its conclusions as to whether such calculations indicate that the REPSA cost thresholds relating to the freeze determination have been exceeded. So based on the numbers provided by Delmarva Power, and based on your calculations, and based on the requirements under the commission regulations regarding the cost calculation, and to the best of commission's ability, given that certain numbers were substituted with proxies, what is staff's conclusion as to whether the 1% and 3% cost cap thresholds from REPSA have been exceeded for the compliance year 2018-2019?
And if I could just clarify that the two unknowns, as we've said from DENREC for that compliance year, is the total cost associated with any ratepayer-funded state renewable energy rebate program, or the total cost associated with any ratepayer-funded state solar rebate program. So those costs are not included in here since they're unknown. And for the total cost of compliance for renewable energy as a percentage of total retail cost of electricity, it has exceeded the 3%.
So let me clarify, because I may have misstated something in my question. So the numbers that we do not have from DENREC, is it accurate to say that they would serve to raise the cost of compliance?
Yes, they are at cost, yes.
And doing the calculation without that cost component, are the 1% and 3% cost caps still exceeded?
Yes, they are.
Thank you.
Clarification, did you say for years 18 and 19, or from 18 to 19?
For 1 year, and it's REPSA compliance year 2018 to 2019. I believe that means June 1, 2018 to May 31st, 2019.
Yes, that's correct.
Okay, so now we know what the Public Service Commission says about whether or not the threshold has been exceeded, and it was exceeded according to staff. And we are in a situation where we're still in Superior Court. We will continue to be there for a while. We have the prospective action in the legislature. We have these pieces of paper which we don't want to be meaningless with respect to the situation. But from my viewpoint, and I've already expressed it, that it's very unseemly and not very beneficial, as we all, I think, should be able to see around here, that to continue the fight while the chance for legislation to cure this fight is pending. And I have deep, deep reservations about legislation being passed. And I tell you that right now, especially if it's going to be co-joined with other legislative initiatives. And I sincerely hope that DENREC has a backup single bill that corrects this issue and doesn't go just with whatever might be in the stratosphere of somebody's thoughts with respect to the way forward. I'm not going to propose any, I think the DENREC's position with respect to its legal position is one that I have to respect. I don't think it's been, they're taking their positions in a fashion that's other than honorable. And I really don't see the benefit of continuing, ordering them to do something they're not going to do. And I think, frankly, what's going to happen is if the legislation isn't passed, especially if the court rules in favor of what the Public Service Commission staff filed, this argument's just gonna go away. And, there's gonna be a freeze, there won't be an auction, and it'll be over with. But hopefully, I'll find two other commissioners that are patient enough that we can wait till July 1st before we lower any supposed hammer to make these pieces of paper more meaningful. So that's where I've been coming from the entire time, and I don't know, other commissioners are welcome to express their opinion, but there's gotta be a next step. Consultation should occur. It's not gonna occur until July 1st, that's the message I'm receiving. So commissioners, do you wanna continue to set deadlines? Mr. Slater?
I'm sorry, Mr. Chair and Commissioners, for interrupting you. Are we gonna know what the numbers are? Because what you're suggesting, July 1st, pushes into the next compliance year, allegedly. And so what you're doing is you're asking ratepayers to pay even more money if you continue to delay it. And I know that we're above 1% and 3%. I don't know what the actual numbers are because staff hasn't provided them. But should we know those numbers before you move forward? And again, I have worked amicably to try and resolve some of these issues, and that has not been successful. But if you move to July 1st, what you're doing is that you're saying, allegedly, that you're moving into the next compliance year, and therefore raising the cost for all consumers when it is clear that you are above the caps now.
Well, I think it's a good question, and I thought about that a little bit, and we don't have some of DENREC's numbers. It doesn't appear to be consequential, probably. So I guess knowing the figure may be helpful. I mean, commissioners, what do you think?
I think it would be important to know, you've said that the cost calculations have exceeded by the 1% and 3%. In the 3% number, how much has it exceeded it? Is it 6%, 10%, or 4%? I think a degree is necessary to determine whether we're, as we've said, kicking it down the road or waiting until July. But are we waiting until July because it's 4% or because it's 9%? I mean, that's, like, the degree that it's been exceeded is important, and I think we have to take into account what Mr. Tweedy has said. Numbers are coming down, we understand why, but if it's a minor exceeding, it's gonna be a different opinion than if it's 10%, when the 3% is the number. So I think that's important, the percentage.
And I concur.
Likewise.
So DENREC reiterates its objection that because these numbers include Bloom Energy costs, which are not renewable energy and therefore should not be included in this calculation, these numbers are vastly inflated.
We made a decision on that, and you've appealed, and the courts will let us know.
Thank you.
Mr. O'Brien, you want to please ask questions?
Solar
to
wouldn't have Bloom
consummate
Energy in
the
it anyway.
argument?
So, Ms. Knotts, what was the percentage cost for total renewable? I think that's what you were asking. The one that compares with a 3% statutory cost cap based on the numbers that you had.
Okay. And again, these don't include DENREC's numbers, which would be cost. And again, they don't include DENREC's numbers, which would be a cost. The percentage came out to be 18.9184%.
I'm sorry, Pam, 18 what?
18.9184%.
9184, thank you. And the 1%?
And the total cost of compliance for solar renewable energy as a percentage of the total cost of electricity calculated to be a 2.0193%.
Just for informational purposes, did you carve out the percentage of that 18% that's can be attributed to Bloom Energy?
No, I did not.
Okay.
I strictly went with what was in the regulation. I can do that.
Ms. Knotts, what would be effect of having the freeze occur sometime after July 1st rather than some date, maybe in April or May? Are we talking, what sort of numbers are we talking?
Well, assuming that you're talking about, are you talking about the next compliance year? Because now you're into 2 compliance years past that. July 1st would be the compliance year 2020 to 2021. What I'm giving you right here is compliance year 2018 through 2019.
Right, no, we understand.
Okay.
Yeah, we're way behind the 8 ball, obviously. So I just want to know in general what the impact of having the freeze occur, say, 6 months from now rather than today.
You're into another compliance.
Yeah.
Okay, is that the only effect?
Well, I don't know if that has the biggest effect. You're into another compliance year, and so the increments increase. The increase of renewables that must be purchased to comply with the RPS.
Right. Okay, that's,
In my understanding, Delmarva would have procured everything that they needed to meet the requirements for the subsequent compliance years after 2018. So, because there is no freeze, so they're continuing to buy.
I agree with Ms. Knotts that I think that this would create, that question is a good question, but it creates a lot of assumptions that I don't think we can answer right now. Other than you would be in a new compliance year, so the rates obviously increased, so the cost to customers obviously increases. But you also have the question of, are you, there's Delmarva's filed for an SREC auction. I mean, there's a whole bunch of variables there.
well, I understand it. Am I right that the auction is in May?
I don't believe that there's actually been a time set for the auction. In talking with Ms. Crumpton, that they would be filing, they did file, and we would be doing an opening order in March. And then there has to be a public comment intervention period and everything else, so it could be sometime in early summer.
Okay, so, Mr. Myers?
I had a whole speech about why you have to act now. But the proposal I added on the last page of my proposed comments suggests this solution, and maybe it jives with what you said, the Chair. You have to remember that under the RESPA law, the annual quotas that Delmarva has to meet go up every compliance year. They go up every compliance year. And part of the freeze determination would in effect say it's not going up from what it was when you imposed the freeze, for the year that you imposed the freeze. So if in 2018-19, which these numbers relate to, the percentage of overall renewables that Delmarva had to acquire or collect for, I don't know the number, it's like 12% or 13%. If you imposed a freeze, that would carry forward until they could show that the amount of money they were going to spend is going to come down under the 3% level for the higher number. That's background. What my proposal does along with you is this, and it recognizes that everybody's behind the 8 ball. There's a determination that they exceeded the caps on both, the 3%, which would include the bloom, the 1%, which doesn't include any bloom charges. The solar, they don't apply any of the bloom charges and bloom collections to the solar. So they're over by double, 2% on that. My proposal would be that you in effect declare a freeze based on these breaches, but you don't have it become effective until the beginning of the 2020-21 compliance year, which is June 1st. And what the freeze would do would mean that for that compliance year, rather than what's set forth in the statute, it's the frozen one that carries forth from 2018. that gives a wash for this year. You're not doing anything about this year, but you're in effect saying the freeze is carrying forward beginning in June 1st of this year, unless two things happen. And it gives one escape valve. One escape valve is if Delmarva's numbers come in for this year, 2019 to 2020, below the caps, you'll lift the freeze. That's the escape valve. And what this does, in my view, is this. One, it satisfies your condition. There's a freeze hanging over everybody that's going to begin on June 1st. The legislature should be well aware of that and act. Fish or cut bait. And you're giving them 3 months. And we don't have any prolonged proceeding in June or July or August. In effect, you make that decision now, it goes into effect unless the legislature wipes all this out, or two, the Delmarva and Denrec can project that for this year, that their cost will come under the caps. If that happens, then it'll go up to what the statute says. That, in effect, I think, gives the legislators a chance to do it. If it preserves consumer choice, because if prices come under the caps this year, they've saved money. And three, I think it gives Delmarva some certainty about how they should go about procuring their renewables for the upcoming compliance year. They should use the frozen number, and if the legislature overturns it, or the escape valve comes in, they can buy some more. So it gives everybody a window of opportunity, one last chance, as they would say, but it doesn't postpone the proceedings. You declare a freeze, but don't have it start until June 1st.
In the little bit of time we've had to think about that, that sounds reasonable to the GPA.
Commissioners, what do you think? That sounds reasonable to me. It hits a lot of boundaries.
There's 1/3 escape valve if Denrec gets some favorable decisions from the bench.
Well, that's going to be automatic.
Well, you have to, Commissioner, you have to understand what's pending before the Superior Court now and what the timeline is. What's pending before the Superior Court is a motion to dismiss by these parties saying one agency can't sue another and ask the Superior Court to sort out their disagreements. And their motion for a stay. A stay is only temporary, and then it's going to move on to, even if a stay was granted, I assume if these parties continue to pursue it, it's going to move on to litigation over the merits. Now, I know Judge Wharton. I've known him a long time. If he's taken this long on this one, it's going to be a long time on the next one. So there's not going to be any quick resolution in Denrec's favor, a final resolution in Denrec's favor for a long period of time if it just proceeds through the courts.
Mr. Tweed, your objections are obviously noted, but if it's
Just sole clarification is that our motion before Judge Wharton is to stay implementation of the regulations. If you were to rule on that, that would obviously have effect immediately.
Yeah, whatever legal ruling comes down, we're going to follow, obviously. Mr. Walsh, did you get that? I mean, for in terms of getting an order together? Okay.
Does someone move that?
I want to move it right now. I move that, to help me out with this motion, we're gonna order, I guess, obviously, number one, I think that it's pretty evident that Denrec is sticking to their legal position and they're not gonna be making a consultation now, today, or in the future with us, so I think that that's sort of a nullity, that there be a consultation. So I would indicate that the staff calculations show that the freeze has been, over the freeze numbers, and given the fact that Denrec is not, doing what I said they were doing, which is pursuing their legal avenues, that the commission find that there should be a freeze, and order the freeze And what's the June 1st, how would you,
June 1st.
effective June 1st?
Yeah.
Effective June
June
1st.
1st, 2020.
2020-21 compliance year.
Right.
But the freeze would be at the 2019-20 compliance year. That would be the level of the freeze. It would be this compliance year.
This year, because we just heard 18, 19, and now we're in 19, 20, and
Yeah.
did they change the numbers of the years in the new legislation? Anyway.
Yeah, I know.
My proposal is the freeze starts, what's frozen is the number, the compliance year that these numbers apply to, which is
1819.
2018-19.
Right.
No, because you don't want
It's
the,
a skate.
you don't want the additional expense.
It's a skate on the intervening year.
Right. Is there, so would you restate my motion, Mr. Myers?
I got it. With the addition of Commissioner Gray's escape valve for the court ruling, it's set out in my
Right.
comments on the last page in the big type. I apologize for the big type, but I'm half blind, so I have to use it.
Chairman Winslow, could I just ask a few clarifying details for Mr. Myers, if I could?
Sure.
I think that they might be critical in
To
this.
decision maker.
So, Mr. Myers, if I understand you, please correct me if I'm wrong. It's based on the 2018, 2019, but right now Delmarva is in the 2019, 2020, and they are procuring, and they will continue to procure until the freeze.
It's a skate, yes.
So they
Because
will-
we're so late in the year, you can't, and these numbers don't apply to this year. The freeze is declared based on overruns last year. It's a skate where the freeze carries that number forward through this year. The escape valve is if the numbers for this year can be shown before June 1st to be under the 3-in-1 thresholds, obviously for the overall, I don't think they can, maybe for the solar they can, that part of the freeze is lifted. I mean, it's sort of a fudge on the thing, but saying, okay, that was 18, 19, you're back on track. So the number, the yearly quota goes up, the freeze to what it was in the statute.
Right,
That's
but
the
it's
escape
frozen-
valve.
But I think what she's asking is it's frozen where?
It's
where for the
frozen at the
argument?
2018.
Which is what number?
No, I'm sorry, your regulation states, because you always calculate whether there's a freeze based on a previous year. Your regulation states that because of the overrun in 2018-19, the freeze numbers are the current year, which is 2019-20, which is 17.5%,
No.
and 2.5%. Well, it freezes at the current compliance year.
You tell me which one it is.
But you can't freeze on numbers you don't have.
Well, yeah, okay, so you would be freezing at 19% and 2% for solar. Minimum cumulative percentage for the 2019 compliance year. The 2019 compliance year is half of 19 and half of 20. And that number says 19% cumulative with a 2% solar carve-out.
So that's my clarifying question. I'm sorry, maybe I wasn't clear enough. So it,
I don't agree with that, but that's,
Well, that's what the PSC regulation says. You freeze it at the
no, it
current.
would be frozen at the 2018. If the
Yeah.
2018, 2019 compliance year is what we're reporting on right now, that would be the year it was
Yeah,
frozen on.
that's
That's the
what
percentages,
we've argued and.
yes.
Well, then I stand corrected.
So, but,
That's part of the motion, is it's 18, 19, because that's the
Yes.
figures we're using.
yes, but when you're talking about the freeze being implemented on June 1st, you've already completed the 1920 compliance year. So those 1920 compliance year would have been at the 19% that Delmarva is procuring.
You're ignoring what happened in 1920 under my proposal. Because you're operating on numbers from 1819.
But then you said about if the level was below the cap, lift the freeze, if
It's a
19
fudge.
and 20.
It's a fudge to take care of the fact that you're ignoring a year.
And I don't believe Delmarva would have those numbers as of June 1st for the 1920.
They can project them. They can project them.
No, it'll be 6 months from now.
May I be heard on this?
Yes.
Please.
Hold on a second, please.
I would just like to echo Ms. Knott's comments and state for the record that Delmarva has already been purchasing based on the 2019-2020 percentages in place. So those contracts and processes are already in order. And it would be very difficult for us to be frozen back on the 2018-2019 compliance year when we've already made commitments for the higher percentage for the 2019-2020 year.
And the future.
Correct.
Right.
So I just want to state for the record that what's being discussed today may create some significant problems based on what Delmarva has already purchased and has in its
I
budget.
appreciate that input. We can just, I guess, amend the motion to indicate that the freeze will be June 1st, except for any contracts entered into by Delmarva Power. No?
We've already, the auction has already occurred for the 2019-2020 year, so those
That's why
contracts are already
Mr. Myers?
secured.
That's why I give them a skate on 2019, 2020. That's why I'm saying you're not freezing 2019 stands as it is with the statutory number. Your freeze in effect just jumps over that year because of the lateness and starts for the 2020, 2021 compliance year and brings forward the frozen numbers to that year.
But I think what I'm hearing is that from the company's point of view, contracts already entered into might have taken into account what they're already doing at the compliance level this year, which is 1920, not 18 and 19.
No, that's why we're going to 2021.
Hold on for a second. I want to hear from Delmarva.
Yes, it'd be.
Jim Jacoby for the record.
Hi. It'd be helpful if we talk in terms of the total percentage, because we are currently executing for the 19-20 period.
Right.
That has a total percentage of 19%. So we're currently in February. We've already been working on a purchase plan for this year to meet those numbers, and we have commitments in place to hit those numbers. So we would not want to see a retrograde percentage set, because I'll be over those numbers based on my purchase plans that are already being worked. So I think what we asked for was, as of June 1st, freeze it at the current level that we're currently purchasing for, rather than looking backwards.
Yeah.
Completely agree.
Yeah.
Completely agree.
Mr. Slater?
It does bring in a much larger issue that this commission will need to address in the very near future, which is how leveraged Delmarva is in long-term contracts on RECs and SRECs. Because that's essentially what you're talking about. On the REC side and on the SREC side, it's through the auction process here. But this commission will have to address that huge disparity in leverage contracts, because that is how that's the position the utility's in, but it's also the position that ratepayers are in, that you have these really long-term contracts and you end up, I will argue, over-leveraged.
Okay, so what number then, Jim, what percentage?
19% total.
19% total, and then for solar, 2%?
Two. Correct.
Okay.
And just to comment on what you said, Drew, our purchasing plan for SRECs and RECs has two components. One is the long-term contracts, which have been in place, most of them have been in place for approximately 10 years. That provides roughly 40 to 50% of our requirements. And then we have a spot purchasing component, where we're buying RECs as we move through the year. We've already been buying those spot RECs, looking at how prices are moving.
Yep.
And so it's really two issues. One, long-term contracts is part of it. The spot contracts, we do have flexibility, but, you know, the rules as of yesterday were I needed to have everything in place by the end of June.
Yes.
Today, if we
So,
rewrite that, I can't
if
take
I-
back spot purchases I've already made.
That's fine. To clarify, so yes, on the rec side, on the SREC side, it's very highly leveraged. And the commission, somebody's got to address that at some point. But not to get.
Mr. Myers? Dr.
You
Brewer?
can choose the quote, I call them the quota numbers, the yearly quota numbers. You can choose to freeze it. I think it's consistent with the regulations to freeze it at the 2018-19 quota numbers and begin that in the 2020 year, June 1st of this year.
Jim, why
But
do
he
you-
just said he can't do that. 'Cause
Well,
they don't
I've heard him
have
say
contracts for
they're
this year.
fulfilling present year.
Yeah.
Are they
Well,
buying
that's
future year and are your long terms?
Right, don't be entering into any long-term contracts.
Well-
That's basically the issue.
Yeah, that's totally understand, and we're not talking about any new long-term contracts.
Mr. Chairman, if I may.
Yes, sir.
Very, very quickly. Whatever decision you come up with all this input, I think the best outcome would be, I'm hearing June 1st as a date.
Yeah.
Instead of using this level and that level, with all due respect, you should just decide on the percentage on June 1, and that'll be very clear. It'll be a one-liner order. My point being that all these caveats and all this is going to be very confusing because, you know, things can change and all that. So if Delmarva is committed to a certain percentage already and that exceeds it, then you just use that number instead of saying 2018 number to take effect on 2019, 2020. Pick a date, pick a number, and just use that as your order. Just for simplicity's sake.
Well, it does have the elements of simplicity.
Yes, it does.
Yes, thank you.
We, I think that, okay, that sounds good to me. The only caveat I make is that I don't want to leave Delmarva Power and Light in a problematic position. So I think the people around the table should understand if in our desire to get this thing resolved, Mr. Myers, just be
Just 2 sentences, and then
Okay.
I will shut up. This is a consumer protection law. It's a ratepayer protection law. It's not a Delmarva purchasing protection law. And the idea was, when you run over these things, that Senator McDowell and Secretary O'Mara said, once you go over, it'll circuit break on it.
Well, we didn't do.
What happened to the consumer protections?
Well, Mr. Myers, we understand at the consumer protection thing thoroughly, but we don't want a party who's acting in good faith and following the existing law and rules and regulations to get hammered. And that unfortunately, what that means is that someone's gonna have to pay for it, and that's gonna be the consumers. And so we're gonna have to do the freeze, and we're gonna have to make possibly an adjustment down the road if we don't anticipate all of the issues and problems this afternoon. So let's, Mr. Stevenson, you did have something?
Yes.
Okay.
My consultant tells me that the regulation does say you freeze at the current compliance year, which would be the 19 and 2%.
May I say something on that? I believe, if I understand it correctly, there's been some argument here today that the regulations apply to DENREC and DENREC. I don't know, there's been some discussion of whether or not the commission has the unilateral right to set the freeze. I'm not entering into that, and Delmarva doesn't have a position on that. However, for the sake of simplicity, I think we've accomplished a lot today. We've gotten the calculations done. I wonder if we would all benefit from taking a pause and thinking about this a little bit further and maybe submitting some papers on this topic so that we can all fully digest what the ramifications are of a potential freeze. I personally don't have that information at hand, and I'm not equipped to discuss all of those potential ramifications on DPL today.
We're gonna, I think it's a great suggestion, but we're gonna put it to bed today. Okay, we're gonna go with Mr. Myers.
Could we, by any stretch of the imagination, have this motion read back to us?
Yeah.
Yes, you can. I move that a freeze on the minimum cumulative solar photovoltaic requirement and minimum cumulative eligible energy resources requirement is declared. Such freeze, subject to the conditions in number 2 above, which I'll get to, shall begin on June 1, 2020, at the outset of the 2021 compliance year. Under such freeze, the minimum requirements for the 2021 compliance years, and Pam, please follow me on this, would be those applicable for the 2018-2019 year.
You changed that to 2009 to 20.
You changed that to 1920, please.
Yeah, I'm sorry, 19 and 20, or was it 2, 19 and 20 or 19 and 2, I couldn't.
It was 19 total.
No,
No,
we're talking about year.
Year.
19, 20.
2019, 2020 compliance year.
Thank you, 2020 compliance year.
Okay. And those, the numbers for that year were,
Don't read that because they're not right.
okay,
I'm sorry.
okay, no, I appreciate that.
It protects Delmarva.
If prior to June 1, 2020, DP&L and/or DENREC, I guess and DENREC, not take the "or" out of there, can demonstrate that the actual and projected compliance costs for the 2019-2020 compliance year under either requirement were less than the percentage cap dollar amount for that requirement during the 2019-2020 compliance year, then the freeze shall be lifted as to that requirement. In such event, the applicable minimum requirement would be the percentage set forth in 26 Delaware Code, Section 354A for the 2020-2021 compliance year. Any freeze imposed may be lifted at any time under the process set forth in 26 Delaware Admin Code Part 3008, Section 3.2.21.7 to 3.2.21.9.
There was also Commissioner Gray's, I think that was in the motion, suggestion that if the Superior Court made a ruling adverse to this, or I don't know how you want to phrase it, adverse, it would be
Well,
lifted also.
I think that would, I don't think we need to put that into an order, that's very basic. Now, is there a second to that motion?
Second.
Is there any further discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed or any abstentions? The motion carries. Well, that was completely unique experience, but I really do sincerely appreciate everyone's input. I mean, it was tough. Poor Mr. Tweedy's got the toughest job. He's got to go back and tell them what this crazy Public Service Commission has done today. But hopefully, it gives us a lot of room to work with. And Mr. Myers, thank you so much. And I guess Dr. Brew is next on the calendar.
Yeah, I see that. Thank you, Mr. Chairman. There is a public comment session in PSC docket number 190314, Verizon Cable Television Franchise, Newcastle, Sussex, and Kent Counties, Wednesday, February 19th, 2020 at 5 p.m., which means in 20 minutes from now, in this very room.
Get out of the doorway. Get out of the doorway quickly. When
And the next commission meeting is March 18th, 2020. So does that mean, for all practical purposes, that this order that you just did, and I'm looking at the orders, gets memorialized in that meeting, or can it be memorialized ahead of time? Because there's no requirement to memorialize in a meeting. Council?
Well, I would like to see it.
I didn't say, I won't circle it. I said, does it have to be, do we have to wait till March 18th meeting? That's my point.
If the vote is on the record.
Yeah.
Individual signatures.
Right. So, off the record, I'll drive to each one of your houses and get the signatures.
At dinner time.
At dinner time. That's him. Thank you, that's all I have.
Is there anyone here from the public that wishes to make comment to the Public Service Commission?
I think you gotta sign this order in a public meeting.
I don't think there's a
You
requirement.
speak by your orders, not by your votes. That was all I always told the commission. So if someone changes their mind before next week or the next meeting, the order doesn't necessarily.
Then that's okay, it'll be ready for next meeting, March 18th.
What
Which-
are you guys doing sitting here?
You adjourned?
Oh, I thought we adjourned.